seated.
Good morning and welcome to the Florida Supreme Court. The first case on our calendar is Johnston versus State. Are the parties ready? You may proceed, Mr. Dalls.
May it please the Court, Todd Dalls on behalf of David Johnston. We're here this morning from the denial of Mr. Johnston's sixth successive post-conviction motion alleging newly discovered evidence that we had filed based upon a newly obtained IQ score of 61 obtained on the WAIS-4.
Let me ask you a preliminary question. When was the WAIS-4 test first available?
In late 2008. I believe the website had said August 2008. The doctors had told me November 2008. And the court will recall, I came on the case just right at the time that the warrant was signed, right there in May. I believe it was like the last week of April, first week of May in 2009. And that's whenever.
Was he without an attorney for a period of time?
Effectively so, Justice Perriente. We had discussed that a little bit when we were here in May, and that the Middle Region CCRC had filed a motion to withdraw that had basically languished in front of Judge Waddles for a long period of time. After the prior mental retardation hearing and subsequent affirmance by this court, Mr. Johnston's counsel, Mr. Mills, withdrew. Another counsel was appointed that indicated that he didn't see any claims. It went back to the Middle Region, and the Middle Region had it until I was appointed after Governor Christ had signed the warrant.
Now, let me ask you about the time limitations that are applicable, and I understand this is a complicated situation, but isn't it the case that there's a 1-year limitation with respect to newly discovered evidence claims that runs from the time that the newly discovered evidence was discovered or should have been discovered through the exercise of due diligence?
I would agree with that, Justice Kennedy.
Okay. Well, now, I understand we got these facts you're talking about whether he's represented or who was doing what, but wouldn't, in this case, the 1-year clock, absent some exception, start running at the time this test became available, generally available?
My argument, Justice Kennedy, is that the clock began to run whenever I became aware of it, as he was effectively without counsel with that motion to withdraw languishing, which would place it in May.
Is there authority to support that? Because it's ordinarily the case that the clock begins to run when you should have known about it through the exercise of due diligence. And obviously, this test is a test that is not something that's secret. It's a widely known test, and when there's a new version that comes out, that's going to be something that would be widely publicly known. So the notion that counsel could not determine it, now whether there's a gap in counsel there and how that would affect this, that's a different question. But absent some circumstance such as that, wouldn't you agree that the clock would start running when the test came out?
I don't believe that that's the way it reads. I believe it reads through the use of diligence. And I can only speak to the diligence that I used whenever I received the case, and I had him evaluated within a week, and that's whenever I learned it. I can tell you,
But if we follow that, if we follow what you're suggesting, when we essentially have a situation where, at least potentially, these claims based on this new test could just kind of be sitting out there, and because counsel didn't happen to find out about it, they could be raised when counsel gets around to checking out alternatives, various courses of action on the eve of execution. And we could face this, what we're facing right now, in I don't know how many cases, but there'll probably be some other cases where there are claims that could be made along these lines. And isn't that a problem? That can just sit there until counsel gets around to it and raise it at the 11th hour.
I believe that's why, Justice Kennedy, that there's the diligence prong, because it's an individualized determination based on the circumstances of the case.
Well, what I want to ask you on that is obviously you've raised a very serious claim. At least I think it's a serious claim if Mr. Johnston is in fact mentally retarded, as contemplated by Atkins and the legislature. You came on the case, you said it was May of 2009?
I believe the order of appointment was the last.
And the first issue you raised to this court, in which you obtained a stay of execution, was DNA evidence would exonerate this defendant. Now, as an officer of this court, and I'm no expert on mental retardation, wouldn't his status, his ability to communicate, his other deficits that would be indicative of somebody who is mentally retarded be something that you would have been able to discern upon your initial meeting with him?
Not exactly, Justice Periente. I had raised a claim that Atkins should be extended to those that are mentally ill or brain damaged, because I thought that Mr. Johnston was in the same class as those that were mentally retarded. Because of the lateness of coming in, I was aware of the 2005 determination and aware of the WACE 3 score that was an 84. I didn't have any other score at that point in time. As I laid out in the successive motion, I had spoke to Drs. Crop and Dr. Eisenstein. Dr. Crop had made me aware that there was a WACE 4 out there, although his schedule did not allow him to be able to go back and administer the WACE 4. And that's why I subsequently...
The real question is, someone with an IQ that is allegedly 61, wouldn't there be some physical manifestations of that would be apparent to someone who is talking with him? If you have to meet with him, wouldn't that kind of IQ sort of be apparent in conversations?
It was apparent, and that's why I had moved to have the Atkins class extended, because frankly I was baffled by the 84. And that's why I subsequently had him tested with the WACE 4, knowing that it was a more accurate assessment based upon the representations of Drs. Crop and Eisenstein, because...
And you couldn't, at that point, find anyone else to conduct this test other than Dr. Crop? I mean, I would assume that the WACE 4 is available to who administers, psychologists or psychiatrists, and that no one other than Dr. Crop, you couldn't get anyone other than Dr. Crop to have done this? I
had attempted to have Dr. Eisenstein do it. He didn't have it at that point. He ordered it, and by the time he got the test, we were before this court, because as the court's well aware, it moves so quickly once a warrant is signed. And I was as well. I was acclimating myself with the case, having been inundated with many boxes of materials and not having had. It's not as if it was my case from the beginning, where I have a breadth of knowledge about the case. So
there's no authority, though, that would suggest that 1 year time period would be told because the appeal of another successive post-conviction motion is pending.
Your Honor, I don't believe that the trial court had jurisdiction to hear the 3851. I filed it while it was still out, and it was ready to be heard immediately coming off the Band-Aid.
But in fact, you filed this while the case was still up here, the other case. So I don't understand I don't understand that about the trial court not having jurisdiction. The filing of the claim, whether it's going to be heard immediately, that's maybe a different issue. But is there any authority that would suggest that 1 year statute is told by the pendency of an appeal of another successive post-conviction motion?
I can't cite to you a specific case other than the concept of if the trial court doesn't have jurisdiction to hear it.
Well, we have cases that say what the procedure to follow, which is it's to be filed and then stayed. I mean, I'd like to ask a question as to, assuming we get past the first prong of timeliness, about whether you've set forth a legally or factually sufficient claim. It's one thing to say that this WACE 4 is a refinement and that it's, quote, a better test. But would you agree that in order for it to qualify as newly discovered evidence that could lead to a reasonable probability of a lesser sentence, or in this case, immunity from the execution, that you would have to show that the prior test did not accurately measure his intellectual functioning?
I don't believe that it. I cannot come and say that it was inaccurate.
Well, if it's not, so here's the problem. If the WACE 3 was not inaccurate, and it was a score that was obtained over a period of not just during the litigation, but also when he was age, I think, 13 or 14, then how are you going to overcome the barrier that it is actually newly discovered evidence, such that it is entitled to, for you to have a whole new hearing on, all three prongs of the Atkins or this court's three-prong test for mental retardation? I'm just trying to see where we would go with this if there isn't anything that calls into question the accuracy and validity of the prior test.
Each version of the test becomes more and more accurate. I would liken it to if we were to compare it to the advance from a sundial to a clock to a digital clock to, as we refine and get more accurate. It wasn't that any of the prior ones were necessarily inaccurate. It's that we have a better idea of where we're at.
I mean, if that's the analogy, there should be no reason for that kind of a span between a 84 and a 61. That's not just saying that's a refinement. That has to call into question that those prior tests did not accurately evaluate his intellectual functioning. Because it's not just, well, it was 2 o'clock 2 years ago on that clock, but now it's going to be 2 o'clock in 10 seconds. I mean, you're talking about almost a standard, at least a standard deviation, right, from 84 to 61. I mean, that's a significant difference.
And it's not a refinement. That was what the circuit court had used. It was a new configuration is what we had pled, that it was a new configuration that added, it was, I believe the quote that I had used from Dr. Eisenstein was that it was a new configuration of 4 index scores rather than just a verbal and performance.
Well, the problem is we don't right now, I mean, and this is where my concern is, I have the trial court's order. The trial court found that there was no evidence presented that calls into question the validity of the WACE 3, but there was no evidentiary hearing, correct?
That's correct, and that was where I had indicated in the briefing that Judge Perry had indicated he did independent research. A lot of what he relies upon to determine that it's a refinement, as I laid out in the brief, came from where in the first page of his order he says he did independent research, and that's not the standard whenever we're proceeding under a newly discovered evidence claim, that is whether the motions, files, and records conclusively refute the claim. What's in there doesn't conclusively refute the claim, and a lot of this would be fleshed out.
So you're disagreeing. The finding that the WACE 4 is not a substantial revision of intelligence testing that changes the science or methodology in a manner that would invalidate the previous WACE 3 test results. Are you contesting that finding needs to be fleshed out rather than just summarily denied?
Absolutely, and I believe when we get into the way that it's newly configured, that would flesh that out, and that would show that is an inaccurate assessment, and that it's not a refinement. It's a new configuration.
Did you plead that?
Yes, I had put the quotes from Dr. Eisenstein and Dr. Kropp that it was a new configuration, that it was based on different factors.
Well, I understand that, but did you plead that the prior test was not a valid test or something like that?
What I pled was that this was more accurate, more reliable, and more valid. I can't, Justice Kennedy, I can't say it was an inaccurate test. It's that this is a more valid, more accurate assessment. Just as when we did YSTR testing, we were able to determine a lot more than if we did any of the prior DNA testing because of the increased accuracy over time. If we're not allowed to come in with more accurate, more reasonable, valid scores, then basically people are trapped and can't take advantage of any advancement in the science. Would be the logical outworking of that if we can't challenge these prior scores with the new scores that are more indicative of the actual intelligence, because the intelligence is always there. It's how we measure it.
Let me ask you about a case where the tests were done years ago and the person was found to be above the level of the cutoff level. And so the claim really wasn't pursued because the tests were done and they just had no claim. There very well could be cases like that sitting out there. Does that mean, is what you're saying now, that everybody who didn't even who maybe never even had a test before that was litigated can now come in and have this test administered, even though the time limitations and the rule for bringing a retardation claim long ago passed? Because this new test or new version of the test is there, that all those folks can now come forward, get this test, and be off to the races on their mental retardation claim.
Not on that standing alone, no, because they would still have to meet the second and third prongs.
Well, I understand that.
In Mr. Johnston's case, he easily clears that hurdle, as he was, for 4 years, he was in the Leesville School for the Mentally Retarded in Louisiana. So I don't know that other cases are going to fall within this. Most of the cases involve a failure on multiple prongs. Mr. Johnston's case involves a failure on that one prong. And within this court's opinion, back in 2005,
well, we don't really know.
The
other prong. Now, I just want to be clear, and I could be wrong about this, but the other prongs haven't been litigated.
They have not been litigated.
So we don't really know. I mean, there's not been a factual determination on those other prongs. We know what you've alleged, but there's not been a factual determination on those. Is that correct?
That's correct, but under the case law right now, as we're here, since it was summarily denied, those facts are to be taken as true, and I had pled out how all of the adaptive functioning information that I had obtained and processed through Drs. Kropp and Eisenstein, of him being in the school for the mentally retarded and being in the special education classes, and talking about how his adaptive functioning was so low that he wasn't even allowed to cook for himself. He wasn't able to drive. He couldn't balance a checkbook. Those kinds of things that we typically look at for adaptive functioning. But I think this is a unique case in the sense that in 2005, both the trial court ordered and this court affirmed based on the basis of that score alone. And that, I think that's a very unique situation where we have evidence now on this WACE-4 that directly contradicts that, and it's the most accurate, reliable assessment with the most valid score that we have, that he falls in that Atkins class.
Just a second. I'm concerned about this procedure aspect. When did you first come on the case? When were you appointed in this case?
I believe it was the last week of April, Justice Labarga.
April of 2009.
Yes, sir.
Okay. And before you had the case, April 2009, when was the last? How long did the case linger with the motion to withdraw from the previous counsel?
My recollection is 8 months, Justice Labarga.
8 months. And Dr. Eisenstein, I believe he conducted the actual evaluation in July?
July 20th.
And the report came out December.
Right. I knew of the score shortly thereafter, July 20th. I had, as pled in the motion, I had sent the investigator out to investigate the adaptive functioning and verify the information we had regarding the other 2 prongs, and then provided that back to the doctors who administered the ABAS regarding the adaptive functioning and made their clinical assessments, and then rendered their reports on in December 2009 and January 2010.
Thank you.
Counsel, where's the finality in this? I know that the most recent test showed that he had an IQ of 61, but didn't the 4 previous tests all score over 70? At 45, he had 84. When he was 40 years old, it was 76. When he was 28, it was 83. And then at 14, it was 80. So there were 4 tests above retardation level before this last test, right?
There was 4 above, and there's 3 below, and that's why this first prong just take.
Where do we stop? We take the best 3 out of 5, or what are we going to do here?
No, we take the most accurate, valid assessment, which is the WAIS 4. The prior scores are only indicative of what his situation was before the age of 18, whether that onset was there before 18, and those are what that's relative to. Now we have the most accurate, valid assessment that he's a 61, and when you couple that with the onset before the age of 18, and that his adaptive functioning is profoundly low. Dr. Eisenstein, in his report that I attached to the 3851, even quotes from a 2002 psychological survey done by the Department of Correction that talks about how low his adaptive functioning is, and so he meets that on many different levels. And I think that's the uniqueness of Mr. Johnston's case, is that it essentially turns on this IQ score. And that's why it's so important as to getting that accurate, valid assessment. I see my time's out, and I'd like to reserve some for rebuttal unless the court has any further questions.
Yeah. You've used your time, but we will give you a minute for rebuttal if you have anything else to add.
Thank you.
May it please the court, I'm Ken Nunnally. I represent the state of Florida in this proceeding. In answer to the question of where do we stop, under this theory, we never stop. Sooner or later, the WAIS 5 is going to come out. And some defendant who has been tested with the WAIS 4 is going to come back in and say, oh, the WAIS 5, it's a lot better. And I show up retarded on it even though I wasn't under the prior one.
But we don't
WAIS
have
6, etc. It's never going to end.
Excuse me 1 minute. We don't have a fully litigated record, do we, so that we can make comparisons? I mean, for example, Mr. Nunnally, throughout the history, science changes and moves. For example, you may have an x-ray machine that wouldn't show certain changes, but now we'd have an MRI. And to know how that's different, would we not need a hearing and somebody to explain the differences? It may be that there are none. You may be correct. But do we have a record where it's this litigated, you have put on your evidence, they've put on whatever they have? We don't have that here, do we?
Yes, sir, we do.
We do have enough?
We have it in 2005. Let me tell you what we have. In the 2005 proceeding, 2 experts were appointed. 1 expert selected by the defense, 1 expert selected by the state. The defense expert was Dr. Salvatore Blandino. And I would refer the court to Dr. Blandino's testimony at record page, and I'm citing to my attachment to the answer. It actually appears twice in the record because Judge Perry also attached it to his order. But record 105, 107, 108, 126, where Dr. Blandino says unequivocally, this man is not mentally retarded, and I believe it's at 126 that he says, this man's IQ has tested the same over the last 31 years. Dr. Blandino also says, and I believe Dr. Pritchard says the same thing, and I can't give you a record cite to it, but I know it's in there because I cross-examined Dr. Blandino, and he says on cross that intelligence is relatively stable over time. He explains why the sub-70 scores are not valid scores. And in doing so, he relies on the notes of the clinician who administered those tests, and those notes reflected that because of emotional issues, I believe was the phrase, these scores do not accurately reflect this man's capabilities, that they are higher than this reflects.
Do you have any reason to believe that the WAIS 4 is less accurate than the WAIS 3?
You're making me an expert on mental retardation, Justice Perriente. There is some, in fact, in internet research, there is some question that the WAIS 4 may, in fact, not be quite as good.
Well, isn't that, though, what, again, the answer to stop the flood of whatever there is? You know, when the ABA report came out, we got some motions about that's newly discovered evidence, and this court made a decision, because it could, without having an evidentiary hearing, that wasn't newly discovered evidence. And we've had several of these waves that each time this court has said it's not newly discovered evidence. My concern here is that because in this case we never looked at the other two prongs, and because we do have this evidence of his early childhood being in schools for the mentally retarded, and because on direct appeal we actually upheld the judge's denial of Mr. Johnston's request for self-representation, saying that his age, education, and reports of the psychiatrist and past admissions to mental hospitals did not make him capable of representing himself. And that was a point on appeal. We have had, there is throughout this record indications that this defendant does have signs of mental retardation. And yet, you know, because we certainly did rely on what happened in 2005, but my concern is that we are guessing about what this 61 means. If it is a more accurate and reliable test, then that's one thing. If it is actually a refinement and or less reliable, then that ought to be known. But right now, I feel like we, the court, would be guessing about it and writing something in an opinion that we have no real basis to, to assess.
Well, Justice Perriente, let me respond to that in this way. The defendant has not alleged in his motion that the testing over the last 31 years, each of which has produced a score at least a standard deviation above the cutoff for mental retardation, were in any way, shape, or form inaccurate.
Well, what does it mean when he says that the WAIS 4 is really a more accurate assessment of his mental and intellectual capabilities? I mean, it seems to me if he's saying that this test is more accurate, then there's something that's not quite as accurate about the test that was done before. He's got to explain 23 points, and he hadn't bothered to try. It's that simple. This is the prior testing, and let me put it this way. Let me back up a little bit. The first mental retardation, or intelligence test, rather, that was given to him over that 31-year period that Dr. Blandino was talking about back in 2005 was the WAIS-R, the first revision of the WAIS test. Subsequent to the administration of the WAIS-R, this man was given the WAIS-3. And guess what? The score was the same. That would suggest, and I would suggest put the nail in the coffin of the notion that intelligence is stable over time. And let me point out a couple of other things Dr. Blandino said that are kind of significant to what's going on here.
I'm a little puzzled by your total reliance upon testimony in 2005 to address something that was not even in use until 2009. I read Blandino's. I've gone through every line of his testimony and all of his explanations with regard to emotional overlays and all those things. How does that explain what is or is not involved with a new test?
What it is res judicata. It's an issue that has been litigated and decided. This is serial litigation based upon
there's
nothing
no question
new.
There's no one's debating that this is that this is not a pleasant kind of thing to continue extending, and these things extend, and this comes up and that comes up, but it doesn't address whether there is some development in science the difference, for example, between an X-ray machine and an MRI. And I don't know that this test is or is not. You may be absolutely right, but certainly Bandino's testimony does not address the 2009 test.
Of course not. It couldn't.
Well, of course, but you're arguing it like that's the be-all, end-all. That's what I'm asking, is why shouldn't we have evidence with regard to what it is, what it does? And you may be correct. But again, to get the answer, we need facts.
Because, Justice Lewis, there has got to be some finality to this case. And finality is not achieved by waiting until the last minute, as we have here.
You know,
this claim,
Mr. Nunnally, finality is all well and good, but what we are faced with here, this court is looking at a test that was done that says that this man has a 61 IQ. And, you know, execution is final.
yes, ma'am,
And
it
if
is.
this man has a valid and legitimate 61 IQ, he falls squarely in the cases that said a person who is mentally retarded cannot be executed. And that's what we are facing. Whether or not this man should be executed without fully exploring whether or not this 61 IQ is a valid IQ for this defendant. And what is wrong with us at least sending this case back for an evidentiary hearing to explore whether or not that is a valid IQ?
There are practical and procedural issues that come into play. First of all, by counsel's own admission, this test was known to him in August of 2009 and could have been raised, and I would suggest should have been raised in this court then.
Listen, you know, Mr. Nunnally, and I appreciate this. You know, we had an execution 2 weeks ago. This court does everything it can when a death warrant is signed to adhere to those time limits. But you know, the issue of whether it should have been brought to, if he had the test since the summer, whether we should have had the motion filed earlier. But what you're really saying, let's go to on the merits, is that whenever it was filed, if it was filed a day after the appeal on the last case was final, it would be barred because there had already been a determination of mental retardation. That's your main point, correct? That we've had a determination, there should not be another bite at the mental retardation angle, correct?
This court, in its rules, established times within which those claims should be brought, and this defendant did not do it, so yes, he is time barred.
Well, I thought, if he had this test since he had the test in August, he'd have a year, and if that's when he knew that there was serious doubt about the prior test, then under ordinary circumstances, he'd have a year from then.
No, ma'am. Well, yes, but I'm talking about a different time bar. I'm talking about Rule 3.203 that sets out in this court's rule when claims for mental retardation should be brought. This man did that, and he lost. But you know
that newly discovered, we're talking here, as Justice Lewis asked you to focus on, as to the exception is if something is newly discovered evidence. You are asking us to make a determination that the WACE 4 isn't newly discovered evidence because it's only a refinement and it wouldn't call into question the validity of the prior testing. My concern is that when you have a test that now shows a full standard deviation difference, and as Justice Quinn said, clearly puts somebody in the range of the first prong of mental retardation with no knowledge about the two other prongs having been litigated, with the history of this man showing indications of mental retardation from early stages. How do we not ensure that what you're saying is correct through evidentiary hearing as opposed to just taking what you're saying at face value? That's my concern.
My response to that would be this, Justice Periente. We fully litigated the issue of this man's intelligence. The defendant has never, ever, ever challenged those results. He says this test is better, but he does not explain why, and he does not allege any problem with either the WACE-R or the WACE-3, and that is a failure of pleading. If there is a problem with those tests, if he contends they are inaccurate, that's part of what he has to plead in order to come in with this.
If this is a more valid and reliable test, and that test says 61, then that by the very nature that something's more reliable, it would say that the prior test is less reliable. I mean, I don't know that we have. I mean, am I missing something? I said, you said you have reason to doubt the WACE-4 and its accuracy.
No, I said there are some questions about it that I know from internet research. I haven't litigated the issue.
But we don't know that. And if it's 61 is a more accurate assessment of his IQ, then that would raise a claim that needs to be at least explored on an evidentiary basis.
Well, let me ask you this. Now, if there's, I can understand more accurate, but does more accurate fit the kind of discrepancy we have here between 61 and the series of other tests that were significantly higher? I mean, so if the notion that the 61 is accurate would call into question the whole WACE-3, it seems to me, because of the magnitude. I mean, it would, if this 61 is accurate, it would seem to follow from that the WACE-3 was not a valid test. That's not been alleged.
No, sir, it hasn't.
But there are two possibilities here. There may be others, but two occur to me. One is that the WACE-3 is invalid, which has not been alleged. The other is that there's some malingering going on here, or some other circumstance that would have affected his performance at the time the test was administered. And
that's absolutely right. And I would add, Justice Candidate, that in addition to calling into question the WACE-3, this also calls into question the WACE-R that produced the same score. And if you buy the defendant's argument that the newest test is always the best one, then that wipes out all the prior testing. It doesn't wipe out just the WACE-3 that showed the defendant not mentally retarded. It wipes out every single prior test, and we start over, and that in turn calls into question the ability to ever establish the pre-18 onset if you are going to wipe out all the prior testing, which this argument does.
You know, it really, in my mind, comes down to why not explore all of the things that you have said in an evidentiary hearing rather than us speculating about whether or not the WACE-4 is better, whether it calls into question the 3 and the R. Why not explore all of this in an evidentiary hearing so that all of us really have something to really pin our hats on? Sitting here today, we cannot really say whether it is or it isn't, because it's never actually been explored in an evidentiary hearing. Maybe you can get a psychologist or a psychiatrist who will convince us that this test is no better than the tests we had before, and that maybe he was, as Justice Kennedy said, malingering when this test was administered. But we really don't have any of that before us. That's the real problem and the real issue, I think, that's before us.
If this court buys the defense argument that the newest test is always the best, if he can find a psychologist somewhere to get a score that helps him, that opens every single one of these cases up. It opens up even the cases that have not previously alleged mental retardation.
Mr. Nunley, we're not in the business of buying anything. We're trying to be in the business of deciding based on facts. Your arguments are not facts. You're entitled to your legal arguments, but you're not entitled to establish the facts without a record. And that's all that the questions are directed to. And you become indignant because someone's going to ask a question about scientific testing that has not been, according to any records delivered to us, been tested in an adversarial way in a court of law. You may be absolutely correct, but don't we operate on records that are given to us? And we've gone through these prior transcripts. We understand everything that you've said, and you may ultimately be absolutely right. But don't we operate, haven't we said we operate on testimony, on evidence presented to a trial judge, so that we know that that is correct or not correct? We're pretty fine on what we're talking about today.
This issue, the issue of this man's mental retardation, has been fully and fairly litigated in the 2005-2006 proceedings. The defendant at that time, who was represented by able counsel, chose not and did not go into the adaptive functioning components that are alleged within the pleadings.
I thought
now,
I thought, because I look back at those the issues on appeal, I thought there was an argument that the lawyer wanted to bring up adaptive functioning, but the trial judge, and the argument then was, listen, if he doesn't get past the first prong, we don't have to look at the other two prongs. So our record doesn't contain any of these school records from pre-18 that shows his marginal functioning in school, able to read at first grade or second grade level. That's not in our record. Do you agree that it's not? And it was something that the defense lawyer said that he wanted to bring up, but the judge said, no, we're just going to do the first prong. Am I wrong about that?
Partially.
I'm partially wrong. Does that mean I'm at least partially right?
It depends. Half full or half empty. It's still got to be washed. Nothing kept defense counsel from introducing that evidence. The two experts testified that because this man's functioning was so high that the standard of the profession did not necessitate inquiry into adaptive functioning. However, that doesn't mean that counsel couldn't have put it in had he chosen to do so. He didn't do it. It could have been done then. That evidence is certainly not newly discovered. It's been around however long it's been around. It could have been used back then and was not.
Let me ask you a question about the other two prongs. One has to do with the onset before age 18. But the adaptive functioning portion of it, is that present adaptive functioning, or do we look at present and past adaptive functioning?
As this court found in a case that Dr. Eisenstein was involved in, present means what it says. Present means right now. Even though Dr. Eisenstein was trying to say present really meant past, and there was a comment about Alice through the looking glass and either the rabbit or the Mad Hatter, I can't remember which one. It's reproduced in the state's brief. But present means right now. Present doesn't mean at some point in time in the past. I mean, the rule, statute, and law.
Of course, that then is so the argument then is the adaptive functioning, if that's true, keeps on changing through time and the happenstance of when the motion is brought. Because if, and again, I think we have had this, because adaptive functioning in a prison setting where you've been on death row for all of this time, what does that mean versus whether this man ever was able to live on his own, write a check, balance a checkbook, go to school. Those are certainly looked at as being indicative of an adaptive function. Wouldn't it bear on that determination in some way, the whole totality of the person's life?
Let me put it this way. Let me answer that this way, and I'm really not trying to evade the question. This court has said that present adaptive functioning has its common meaning, which is right now, today. I suppose the individual's prior adaptive prior behaviors, would be arguably relevant to the pre-18 onset component, but as far as meeting the present adaptive functioning component, no, they do not. Any evaluation, any one of these evaluations, no matter what test it is, no matter what it is a snapshot of that defendant's functioning that day. He may be having a good day, he may be having a bad day, but the bottom line is he can't fake smart. That is something we know. I know I've said that before in this court in these cases, and the bottom line to all of this is this man has tested consistently above the level of mental retardation This court has upheld that finding that came following a full evidentiary hearing. There is no assertion whatsoever that any of that prior testing was so wrong that it was 23 points high. There has never been any such assertion. This issue has been decided, it has been fully litigated, and it's time for this sentence to be carried out. Thank you.
And thank you. Mr. Dalls, we'll give you a couple of minutes for rebuttal.
As to Justice Perriente's question regarding whether this had been, the adaptive functioning issue had been litigated before, when you look at the opinion from the prior case, Mr. Mills actually made the argument. I'm looking at 960 Southern 2nd 761. And this court said, Johnston argues that the trial court erred in finding him not mentally retarded because the experts appointed by the trial only considered the first prong. The court went on to find no error in within the testimony of Drs. Blandino and Pritchard. They both said they never even considered the second and third prong because he didn't meet the first prong. So what's before the court is what we've alleged in the successive motion that at this point is to be taken as true.
Now, why is Mr. Nunley not correct that this has been litigated for years, and we go back through and we see all of these scores, and then all of a sudden we've got a new test? Why is that not like or similar to retesting? We can always find a different expert. We can always find something different to bring up. Why is he not correct in that this is what this is? This is just a step in these standardized tests that have been developed, and because there may be some changes in the test does not necessarily translate into what occurred before is wrong, and that's what we're dealing with here.
Because the literature says these are the most accurate, reliable test. It's not as if it's not as the situation where the experts are looking at the same data that these other experts were looking at and came up with a different opinion. There's different data out there, that being the WAIS 4 that wasn't present in 2005, that Drs. Blandino and Pritchard, it would be impossible for them to have considered.
But you would agree that if Dr. Pritchard looks at this and says, and gives a reason for the disparity, trial court could find that in fact this isn't newly discovered evidence. It's just it's actually an inaccurate test because one of them has to be inaccurate. Would you agree with that?
I think it's clear from the literature and from what we've alleged that the WAIS 4 is more accurate. I don't know what Dr. Pritchard would or could say.
Well, I mean, but that's certainly
call it into question. But what's before the court now is that we have the most accurate.
But you would agree that if the court hears from whoever the state puts on and who explains the discrepancy in either the ways or as to why this was an aberrant score, that finding would be something that we would have to affirm on appeal if there's credibility determinations.
If the state was able to produce competent, substantial evidence and the trial court ruled that, I think that would fall within the court's case law that governs that. Not knowing what was said, I can't properly respond. I don't think one way or another other than to say that it would have to be competent and substantial.
And Mr. Doss and Mr. Nunley, thank you very much for your presentations here today. The next case on the court's agenda is Treese versus State. Mr. Olive.
May it please the court. My name is Mark Olive. I was discharged as counsel for Mr. Treese in the lower court pursuant to the remand and relinquishment from this court. And I appear here today pursuant to Rule 3.851I. The court has asked us to address two questions. One, whether the lower court abused its discretion, and the second, what, if any, effect should be given to the letter or letters from Mr. Treese.
Now, Mr. Olive, this is one of those cases. I think we can also ask the same question that was asked in the last one is, when does finality finally kick in here? Because as I understand this, Mr. Treese has vacillated back and forth several times as to whether or not he wants to get rid of his attorney and give up all post-conviction proceedings. And so with that in mind, why should we now say that his waiver, previous waiver, is invalid?
I think that this is a problem that will vex the court on occasion under this rule. And I actually have a rule or a process to propose to the court. And that is that if the waiver isn't final, and in this case it's not final. If
the waiver is what?
Is not final, because this appeal is pending, and he has a right to be heard in this appeal. And so the appeal is here. It's unlike James, where there was no appeal. If the appeal is pending, you can take back the waiver once. And I submitted a case yesterday to the court, St. Pierre, and I gave it to the state as well.
A federal court case?
Yes, where the circuits have said, okay, if you want to represent yourself, if you want to give up your appeals, you're free to do that. But if you come back and say you won't counsel, we'll give it to you, but that's it. We will proceed.
Didn't he give us the chronology? First of all, has he had a 3.851 evidentiary hearing?
We had a hearing, and we had the appeal pending.
Okay,
filed our
all right,
brief.
but we haven't. So we didn't. This isn't a case where we've previously decided a post-conviction motion.
Okay. In this court.
And so it was your brief on the merits, and one of the issues was this CBLA issue,
correct.
Which is now is testing that's been called into disrepute. But wasn't there a prior request by this defendant to waive all of his post-conviction?
There was.
And that was back in 2000 or 2001?
That's correct.
And then a death warrant was signed.
Correct.
And then he said, no, I do want to go ahead with it.
Correct.
Well, why, under your theory of you get one chance of changing your mind, wouldn't that have been his time? In other words, he had said, no, I don't want to. I think this court actually either dismissed the appeal, and he said, no, he did want to, or dismissed whatever was pending, and we allowed him to go forward. That's what happened in this case.
No, actually what happened, close. And if that was the rule at the time, and he knew that was the rule at the time, then he would have to abide by it. But what happened was he had filed a 3.850. He asked that it be dismissed. The judge allowed it to be dismissed. But this is what the judge said to him, and this is an August 3rd, 2001 order. I don't have the cite to the original ROA, but it's August 3rd, 2001. The judge entered an order, and he said, by copy of this order, Mr. Treese is requested to immediately notify this court should he change his mind at any time and desire appointment of counsel, and I've got an ellipses here, for any purpose. So the judge told him, if you want a lawyer, tell me, please. And he ultimately did. And the judge allowed the 3850 to be reinstated. It never got to this court.
So what you're saying here is the waiver's not final because it's on appeal?
Correct.
So this is why you're saying it's different from James, where, to give us again the distinction with James.
Well, what happened in James is, according to the court's opinion, Mr. James did not appeal. He was told he had the right to appeal, and he didn't do so. And so why would he appeal? He would be appealing his own decision.
But there wasn't let me make sure, because the case 07-1353 has two initial briefs, right? Correct? You've got a brief on the merits.
Correct.
And then you've got the brief on the issue of whether on the waiver.
And there was a stricken brief. We filed a brief that was 70%, 80% innocence. The state moved to strike it, so that may be one of the briefs that you're...
So right now, we still have on appeal the appeal from the original and only post-conviction proceeding.
That's correct. And you have a state habeas. There's been no waiver of the state habeas.
So
Well, when you just to clarify that, you said there's been no waiver of the state habeas. Were they filed simultaneously?
The appeal and the state habeas were filed at the same time.
And so when you say you want to waive all post-conviction, you're saying that does not include the habeas?
I don't think he was asked about a habeas in the lower court.
Well, let's be. I mean, again, you're being fairly candid with us. Clearly,
I'm sorry?
I feel like you're being candid with us about what to do with this. What is the let me go back. It feels to me like Mr. Treese is gaming this system. That's what it feels like. He is, one day he wants a lawyer, next day he doesn't, one day he wants a lawyer. And I am offended by this process. If this man thinks he's truly innocent, this is then is one point. But if all he's trying to do is prolong something, which he has so far successfully done, then we ought not to approve that kind of behavior.
I agree with that. But
and Judge Bennett, I mean, there couldn't have been a more thorough colloquy Judge Bennett went through, which I don't think is what the federal courts have, where he asked him every which way. Are you sure? You understand you have a pending appeal? Yes, I know that. Nope, I want to give it up. Are you positive? Yes, yes, yes. Do you think your attorneys are good? Yes, I know my attorneys are good. So this is not a case, as you as his attorney, where they're disgusted with their attorney. It's not that situation. So what do we do with that knowing waiver?
I think that you have to have a fact finding that he's gaming the system. I think that the judge needs to say, that's it. And this judge didn't do that. This judge has seen this defendant for years. And he said, I'm dismissing this with reluctance, not with spite, not as punishment, but with reluctance. This man is on death row. It's the most depressing location in the world. He has mental illness. There's no dispute about it. Mr. Dunn told the judge he needs to be medicated. If he were medicated, he wouldn't be doing this. So if we're going to turn the question, if the answer is going to turn on bad faith and gaming the system, I think there has to be a fact finding.
Well, let me ask you this.
There's no fact finding.
If we accept your position and we allow the appeal to go forward on the merits, and he again writes a letter to this court in 2 months saying, no, I want to give it up, would we have to now send this back to the trial court to go through the whole procedure again? Or are you saying that in one more letter, and even if he's not on his meds, and that's it?
He doesn't get to do it. Yeah, under the case that I submitted yesterday, here's the language from St. Pierre 217 F. 3rd 939. In circumstances similar to those here, we've adopted an approach that quickly and efficiently puts an end to endless vacillation and allows resolution of the cases. That approach takes a retraction of a waiver as the final word. Now, you can go either way. A retraction of a waiver ends it. You don't get to do that anymore. Or a waiver ends it. You're not going to have counsel and you're going to be executed. That process has taken us several years. This process of, no, you can't do it anymore. You do have a right to go pro se. We let you go pro se. Then you abused that. At trial, someone who goes pro se can be controlled if they're abusing it. You can force counsel on them. So under these circumstances, if you're going to vacillate, you get one. That's it.
Well, there's no one bite rule in the rule, right?
No, there isn't.
You're asking us for the first time to put that into the rule.
I think this is the first time this rule has actually been before the court, just as this rule. I mean, in James, you mentioned it, that it had passed. But I think this is a case of first impression, and I think the court could do that. And as a case of first impression, my two arguments are, he's entitled to be heard. The rule says he can file a responsive pleading. He has, by letter. And his responsive pleading is, I agree.
Well, would you say, this is what to me, distinguishes this from another case. The fact that there's still this pending appeal from the post-conviction, the original post-conviction, would you make a distinction between where the case is in its post-conviction posture as to whether how many times, this one change of mind rule?
I mean that we've already filed one brief. Would that make a difference? Would it make a difference if there was a response?
I mean, what impresses me about this, what causes me concern is that there are seems to be some substantial issues to explore in the guilt phase here.
Correct.
That have not been explored. And I think the court, at some point, even though we allow volunteers to be executed, that we also have some obligation to ensure that the person, that if there's issues on his guilt, and I don't know there are or not, but that we at least have a chance to look at that. So that, to me, that puts me, in terms of whatever the policies are that we're looking at, into another box, and I don't know if I can articulate a legal reasoning.
That was our third argument. It was our main argument in the brief that got stricken, but it's our third argument in our current amended brief, and that is that under these circumstances of innocence, the waiver shouldn't be entertained because his execution, if innocent, should not have the imprimatur of this court on it. This is indeed a civilized court, beyond civilized. I've been practicing in front of this court for, I was counting up to you this morning, 25 years, and this court is serious about these cases. And someone who is distraught, who has brain damage, who may need medication, who's been sitting on death row, if innocent, in a pretty depressed and unfair state of mind, we could have some understanding about that. And this court, if it sees the issues, could address it. And we have the CBLA issue in the case.
Well, what you seem to be saying is we should just repeal the rule. We should
have a rule like this to permit anybody to have a waiver. Is that what you're saying?
No, I think that applying the rule comes to this result as well. The rule says his waiver is not final. He's got an appeal. If it's not final, then what does that mean? Can he not revoke it? The rule also says we will hear from you in a responsive pleading. It doesn't say an opposing brief. It says respond. And why would you want him to respond unless you wanted to hear what he had to say? And he did respond. So
isn't the appeal really more to make sure that there was competent and substantial evidence before the trial judge when the trial judge made the determination that the waiver was voluntary and knowing? That's what the appeal is all about. Really?
Then why hear from the petitioner? I mean, the non-petitioner. Why should he speak? I mean, he's already spoken, but he has a voice again in this court under the rule. What's the purpose of that? It seems the purpose of that is to hear what he has to say, and he spoke.
It goes to the issue, it seems to me, that is before the court, and that appeal is whether or not it's voluntary, or whether it was knowing. That's what the purpose of it is.
But I think one of the major purposes of this rule is for this court, as in every death penalty case, to get to look at what happened. I agree with that. But there's no reason to hear from the inmate and have him respond. It's fine. When does it become final to him? This was troubling me. What if he had written another letter to you before the case got relinquished? Would you have relinquished it? When he went in front of the judge in the lower court.
Well, maybe the finality should be at the point where once a defendant in fact says, I don't want to go through the post-conviction process. Yep. I don't want to have an attorney anymore. Once the trial judge makes a determination that was knowing and voluntary, then that should be the end of it.
But it's not. We have an appeal. It isn't the end of it.
Well,
we have an appeal.
Once the appeal of the trial court's decision that it was knowing and voluntary is over, maybe that should be the point where
when that's
we
over,
don't accept any more, vacillating back and forth from the defendant.
Well, my proposed rule is if the waiver is not final, meaning the appeal is not over, you may take it back one time. That's it. If it is final, I haven't gotten to that part of it. If it is final, you can't take it back absent some exceptional circumstance or extraordinary circumstance. I don't have any quibble with that rule.
Well, are you arguing that we should change the rule because you don't have a good argument as to why we shouldn't enforce this rule?
No, I'm trying.
What about the rule we have where there's not a one-bite rule? Why shouldn't we enforce that one?
Well, the way I read this rule is it isn't final yet. His waiver is not final. It's on appeal. And he can speak. This is the rule, right from the rule. If he can speak, what can he say? The way you're interpreting the rule is the only thing he can say if he speaks is, I still want to waive.
So it's like a voluntary dismissal.
Pardon?
You're treating it like under the civil rules.
You got me on civil rules.
But wasn't the purpose of the rule? And when I first came to the court, we had nothing. There was nothing in place. There's no way to look at these to try to protect society and the individual. And the rule was adopted not for the purpose of allowing additional changes of mind, but to view what's in the record and to make a determination, as Justice Quince has said, that this was a valid waiver, not to allow an additional period for this going back and forth. But again, I mean, we understand that certainly these situations can come up from time to time.
Right.
But the rule, I mean, you have to admit, was designed as a protective measure for what has occurred, not to permit a vacillation back and forth. I mean,
it's to be sure that the record supports the waiver.
Yeah.
I agree with that. Yeah. But then we've got you can hear from the petitioner. Why? I have no idea why that would be there, other than for them to be able to actually speak what their mind is.
As a practical answer, I'm not sure that it was put in there for a particular reason.
It's there.
It was to allow participation in the process, I think, but not to cover what you're talking about. It was not designed for that. It may do it, but it wasn't designed for that.
Let me make one final point. With the comparative bullet lead analysis issue that's in this case, say you let him waive and you uphold the lower court opinion. He could file a successor with CBLA, right now. It's in this case. Your case in Wyatt, I haven't cited it in the brief, but in Wyatt, and I can submit supplemental authority, this court remanded to file a successor, if appropriate, on CBLA.
I thought he agreed to not just discharge counsel, but he wanted to waive all post-conviction proceedings.
Waive his first post-conviction proceeding, that's right.
You're interpreting the waiver to be only for that one proceeding, that after doing that, you can still file a successive, is what you're saying.
If new evidence of Brady violation comes up, why couldn't he?
Well, I'm
waiving my first 3850, but now I've discovered I was framed with this evidence. Well, now I want to file a successor. I don't see why I wouldn't be able to do that.
Pro se.
Well, that's fine.
But it said post-conviction proceeding. It doesn't say first post-conviction proceeding.
Which says that?
The rule.
Oh, the rule.
Yeah.
See, that's why I think that in terms of how we want to interpret this, to have it orderly, there is something to be said about that we don't, again, this idea of the gaming of the system. If the fact that this is still on the first post-conviction,
yes,
and that it's been done, it's being retracted before the waiver is final on appeal, seems like a different situation. If you say, no, we went through this whole procedure to just let him waive this one, but he can come back and keep on filing, that would really be an abuse.
No, he can't come back and keep on filing, but if he discovered fraud, why would he not be allowed to file that? It seems odd that we would cut him off forever if he's found something that really affects.
Well, then we'd have to come up with the law about which ones you could raise if there is truly a claim of innocence.
The 3851 rule says what you can raise as a successor. It says things you could not have discovered in the exercise of due diligence, misconduct by the government, things like that. So it's pretty restrained.
Well, I think that really might be an issue we might have to address at another day. But you are well into your rebuttal if you want to say
the
time you have left. Mr. Ake.
May it please the Court, Assistant Attorney General Stephen Ake on behalf of the State of Florida. This Court is here today to address the issue of whether the trial court abused its discretion in finding that Mr. Treese's waiver of all collateral proceedings and discharging his counsel was a voluntary, intelligent, knowing waiver.
Mr. Can he do that? Can he, because we do have this case involving CBLA where the federal government has admitted that it's used, I don't know what they call it, junk science, but discredited testimony in the comparative bullet lead analysis. Could he bring up himself? I mean, a
Not at this point,
subsequent
Your Honor.
post-conviction?
That was part of his amended post-conviction motion.
But I'm asking you, if something else came up, I mean, do we contemplate that somebody who has said, I want to waive all post-conviction proceedings can bring up something else that comes up?
I
and
believe
discovered
if
evidence?
something were to come up in next year or something like that, and this court, affirmed everything that's taken place to this date, I don't know that there's a bar or that there's any case law on that.
Well, if
instance.
that's I appreciate your candor. So in this case, and I know this is to me different than James. Do you agree that at least it's in a posture different?
In posture, procedurally, it's slightly different, but I think the rationale of James certainly still applies, that a simple changing of the mind of the defendant is insufficient to undo that prior waiver.
Well, where was, though, in James, wasn't there a 2-year gap?
Well, what happened in James was what took place was predated the rule. The rule kind of came about during the James thing, and what happened is he discharged his counsel and waived everything prior to there ever even being an evidentiary hearing, and was given the right to appeal that, and nothing happened because the rule was not in effect. Had the rule been in effect at that time, it would have automatically been appealed at that time. Same as in our case. In 2001, when the court did the DeRocher hearing, if subsection I 3.851 was in effect at the time, it would have come up to this court, and this court would have reviewed it at that time. But obviously, that rule came about, I believe, at the very end of December of 06, early January 07 is when it was effective.
Well, what's the harm, other than in terms of the integrity, compared to the integrity to the process, when there is a pending appeal like there is here, and the record's already up here, we've had an evidentiary hearing. There are some questions about guilt, which could, I haven't looked at the record, so I don't know. They may be completely bogus as far as what is being presented. I don't mean bogus, but without merit. I shouldn't say bogus. Yes. I apologize for that. But and the appeal of the waiver is up here, and when we ask for a response from the defendant, he says, "No, I don't want to waive." And what Mr. Olive is suggesting is that he ought to be able to retract it once, and then that's the end of it. Right. Is there such a we don't have that many of these cases. Is that such a disruption of the system versus getting to make sure that the conviction has integrity, and that when we are ready to execute this person, that we can feel with some level of confidence that there has been that justice has been, that all aspects have been looked at to make sure that we can say with confidence that this person is ready for execution?
Well, I believe by Mr. Treese's actions, he has definitely been manipulating the system and delaying the proceedings quite a bit. In this case, you're right. We did have the evidentiary hearing. Counsel at the time he was represented by counsel, and he filed a brief. He then indicated he wanted to waive.
But do we know if he's manipulating it or he does have mental illness that is causing these problems? I mean, again, we see, and believe me, I could name on a couple of hands some of these frequent filers of their own motions. I don't think Mr. Treese is in that category. He's written a letter saying, I do not want to waive my post-conviction proceeding.
I don't believe the mental illness evidence is not that strong. I believe he has definitely been doing this with an eye towards dragging this out as long as he can, and he has succeeded in that. I mean, we had a DeRocher hearing in 2001, and here we are in 2010, basically at the same point in time.
Well, there's been in between that. There was a full evidentiary hearing.
Right, but at some point, there has to be some finality in this, and when a defendant, this court has held, starting in DeRocher and numerous cases thereafter, when a defendant is competent and makes a knowing waiver of that, this court will uphold that waiver. And then in James, it said, simply changing your mind is not sufficient to go back and undermine that previous waiver. And if this court adopts this rule that he's trying to promulgate, that's just going to lead to more instances of abuse in the future. I can see defendants doing this all the time, and basically dragging the post-conviction proceedings out.
But if they actually have the right still to file a successive post-conviction, which again, I don't remember any of these defendants who have truly said, I want to give up my rights doing that. So that's why that surprised me. I mean, usually the so-called volunteers really do want to be executed. And, and many, actually, under the last 8 years, there have been
I think James is the only exception, Your Honor, of all these waiver cases.
So we don't really have a situation where, that's why I'm concerned about making a statement that this is, that we are prolonging a case as opposed to just trying to make sure that when someone says they do not want to waive their post-conviction proceedings, that we look and say, nope, it's too late. We're not going. But you can file something in the future if you want. I don't like that idea either.
No, I'm not sure, and I'm not sure that. Well, let's put it this way: I'm sure that a defendant pro se could file something. Whether it would survive anywhere, I don't know. But I'm sure they can certainly file something. But whether it would be time barred or we would argue that it had been waived, that would be something that we'd have to take up. I haven't seen that example before in this court, so I don't know what would happen under that scenario.
I just would hate that this, the time comes for execution and then all of this starts coming up again, and, there's that unease that you have when something hasn't been fully, put to rest.
Certainly understand that, Your Honor, but we would submit that in this case, by going through with the DeRocher hearing and making that waiver in front of the trial court, that he has to be held to that, and that we have to have some kind of finality here, or otherwise it will just lead to people changing their mind, and they'll say...
I understand his argument regarding this rule to be that because he has filed a letter saying, I changed my mind again, that suddenly that somehow changes our review of the case. And that because this is not a final determination yet because of the appeal, he's yet ready, able to change his mind again.
No, Your Honor, the basis of the rule is to just review the trial court's DeRocher hearing, and we'll find out whether there is evidence that supports his finding that it's a voluntary knowing waiver. That's the only thing that this court is doing on the appeal process in these waiver cases, is to determine whether it was a knowing, voluntary, intelligent waiver. And in this case, they have to show that the trial court abused his discretion in that regard, and they can't show that in this case, given these facts.
During the course of either the DeRocher hearing or at some other point, was Mr. Treese's competency called into question, and have there been any competency determinations in the last few years?
One of his experts at the evidentiary hearing, Dr. Crown, found him competent in 2006. Dr. Marin, the other expert in that post-conviction proceeding, testified that he didn't test him for competency because he relied on a previous doctor's determination, Dr. DeClure, who found him competent at the time of trial. Of course, Dr. Marin didn't indicate that he was incompetent. Now, his discharged attorney, Mr. Dunn, at the hearing did mention the term. I think he said he had questions about his competency, but in the same breath he said, Mr. Treese is an intelligent man. He understands what's going on in this case. He never filed a formal motion to determine competency, and I don't think there's been any showing that Treese is not competent in this regard and that he didn't understand the nature of what he was doing when he did this waiver. And that is what they have to show. Under this court's case law in Slauson and Castro and all those cases, they have to be able to introduce some type of evidence that would rebut the finding of competency. In this case, we've had judicial determinations of competency at the time of trial, prior to trial, and then in 2001 when they did the DeRocher hearing back in 2001, the court found him competent then too. So he's always been competent, and there's records in the post-conviction thing that back in the 70s he was found competent when he was getting discharged from the Marine Corps. So there's never been a single doctor to indicate that he's not competent. And
but the Marine Corps, when he was discharged, that was when he was 17?
Yes.
I don't know that the competency was called into question, but his...
It was for his proceedings.
It was what?
It was for his discharge proceedings, I believe.
But why was he discharged from the Marines?
He apparently cut another inmate.
But what was their diagnosis about his mental status?
Back at the time of the Marine Corps, I believe there were 3 diagnoses. I believe one was paranoid delusions. I honestly, I don't...
Well, there were some... I mean, he's had a long history of documented mental illness. I mean, that's different. He can be competent, but can you not be competent and mentally ill?
Certainly he can be, but I would debate the whole that he has a long history of mental illness. Other than the Marine Corps, I don't know of any history of mental illness that he has that's ever been treated. He was living a life. He ran a computer business for 6 years selling computer chips. So he was functioning out in the everyday world. I don't believe there's any kind of documented history of him being in any kind of mental institutions or anything like that.
So that was just an aberration when he was 17?
I don't know what happened. My understanding from reading it was he did cut this guy as a favor to him because that guy wanted to get out of the Marine Corps. I don't really know the details of that incident, but he was discharged. I forget the terminology. It wasn't an honorable discharge, but it was discharged. It wasn't a dishonorable discharge. It was something else, and it was a result of. And my understanding from it was he did that as a favor to this individual to try to get him out of the Marine Corps. But back to the facts of this case, we have a very good colloquy by Judge Bennett, as this court had noted. Treese is indicating that he's waiving everything, including his habeas, state habeas, and all his post-conviction proceedings. And there's no evidence that that was not a knowing and voluntary waiver. And I would submit that the fact that he has simply changed his mind under James is insufficient to change it. And we would ask that this court dismiss his appeal with prejudice. Thank you.
Thank you, Mr. A. I believe you got about 45 seconds, but we'll give you a minute or so to,
I think this will
if there's
do it.
anything significant you need to.
Just one thing, and that is, I think that it's not just whether the record supports the finding of the judge or not. The judge can abuse discretion by not following the rule. And in this case, at a pre-hearing hearing after the relinquishment, counsel for the state said to the judge, if the court, and so this is page 39 of volume 1 of the supplemental ROA, if the court has any questions regarding competency, I don't know whether you're prepared to appoint experts to go up there to determine competency at this point. So that was presented as an issue to the court. The court didn't do that. And then Mr. Dunn, in talking to the court at the end of his presentation, said, the Marines have documented his brain damage. He suffered trauma growing up. He needs medication. If he got the medication, this wouldn't be happening. He's not ready to give up his appeals. He needs to be medicated. He needs to ensure that he has the chance to do what has to be done, and I have questions about his competency. So I would argue that at that point in time, it was an abuse of discretion for the judge not to follow the rule and appoint 2 experts. I don't want to go back down to the lower court and do that. I think the waiver of the waiver is sufficient at this point in time. And if there's any questions, I'll entertain them, but I've got 8 seconds.
Thank you very much, Mr. Oliver and Mr. Ake. The court will take its morning recess for 10 minutes.
Please rise.
next case on the court's agenda is QBE Insurance Corporation versus Chalfant Condominium Apartment Association. Mr. Cantero.
May it please the court, Raul Cantero for the appellant, QBE Insurance Corporation. I'm reserving 5 minutes for rebuttal. This is a case where we have five certified questions from the 11th Circuit Court of Appeals, and I intend to address them in order unless the court dictates otherwise. The first certified question is does Florida recognize a breach of the implied warranty of good faith and fair dealing based on an insurer's failure to investigate and assess its insured's claim within a reasonable time? We submit the answer to that question should be no. The common law has never recognized a cause of action for first-party bad faith of an insurer. This court has said as much in several cases, many of them recent, Talent Enterprises, Lafayette, and most recently, Allstate Insurance versus Reese.
Your opposition seems to be taking a tack that this is somehow different than, quote, bad faith.
Yes, they are, Your Honor.
And would you address that aspect?
Yes, Your Honor. Yes. There's no difference whatsoever between what they want to impose as a common law claim and what is now in the statute. If I can read you the statute, and I'm sure you've read it many times. Read it many times. But the important thing about it is that it says that it provides a cause of action, a civil remedy, for not attempting in good faith to settle claims when under all the circumstances it could have and should have done so had it acted fairly and honestly toward the insured. So really to call the statute a bad faith statute, as we all do, and it's the common parlance, it's a misnomer. It's not a bad faith statute. It's a lack of good faith statute. And in fact, the reason it's worded that way is because of pre-1982 Supreme Court cases that specifically said we don't recognize a common law cause of action. The statute was specifically designed to remedy that void, and that's what the statute did. In fact, in Reese, this court said that the statute extended the duty of an insurer to act in good faith and deal fairly in those instances where an insured seeks first-party coverage.
Is there the court, before the statute went into effect, had not ever recognized a common law claim, as you say, for first-party bad faith or lack of good faith. Mr. Rogo, Mr. Rosenbaum have said in their brief that we were against the majority rule at that time. Is there, because now that there's a statute, would our ability to say, well, we think it's a good idea to have a common law cause of action be different because now there's a statute that's essentially regulated this area? Do you understand? In other words, versus that we were being asked now to say you were wrong before, there should be a common law cause of action. Right. How do we look at that issue?
In other words, if we were having this conversation in 1981 before the enactment of the statute, I would say, well, maybe you have a point. There's a third-party common law cause of action. There should be a first-party common law cause of action. But we're not in 1981. The statute was specifically designed to remedy that, to fill that void.
But what about the part of the statute that they point to that says that this does not, I don't know if they use preempt any other remedies that would be available? What does that mean?
Well, that means that if there are existing common law remedies, such as the third-party bad faith,
but that's but it's 624.155. Is that both first and third party?
Both first and third. So that's what it's designed to say, is say you still retain that common law third party bad faith action under the common law.
Now you agree that, I mean, what we're talking about in terms of the money here, well, two things. You think that because it was all tried together,
correct,
it infected the determination of the damages. But the allocation for this breach of good faith or whatever was $271,000.
Officially, correct? Yes.
Is that is there a would those damages be recoverable then under 624.155? Whatever those damages are. What are those? What do those damages
They
represent?
asserted over $400,000 in interest from a $15 million loan that they obtained to make the repairs.
So delay, basically, because they didn't adjust the claim promptly and pay,
Yes.
that they were forced to have to go elsewhere. And,
Yes.
and those would be damages recoverable under 624.
4155, yes.
Now, let me ask you this. One of the arguments, as I understand it, they're saying, making here is, I'm going to the bifurcation argument, and that is that in this case, there really was no liability issue, that this was a covered event that the insurance company would be liable for, and it really came down really just to damages, and that is whether or not the damages exceeded the, what do you call those things? Deductible.
Yes.
And so that's their argument as to why you really don't need to have a bifurcation here. And what is your, because it seems to me that when you really step back and look at it, there really wasn't a liability issue in this case. So,
right. Your Honor, the cases don't talk just in terms of whether there was a coverage determination. Although some cases talk in general terms, just like we call it a bad faith statute, we call it the coverage case and the bad faith case. It's not really the coverage case. It's the liability and damage case for breach of contract, and then the bad faith case. And in fact, a lot of the cases from this court has said, like Talit Enterprises and Vest say, it doesn't accrue, the bad faith action doesn't accrue until the liability and extent of damages have been determined. So it's not until we know, okay, what's the breach of contract damages, that then you have an accrued bad faith action and you can file a cause of action.
It seems to me that under this, that it's really to a defendant's advantage that it not be bifurcated, because once it's bifurcated, or let's assume it's not bifurcated, you can protect an awful lot of material that may otherwise be discoverable if it's bifurcated.
Well, it all depends on the judge. That hasn't been determined, Your Honor. One of the arguments is if it's not bifurcated, then we get that discovery. So that really, since we haven't had that cause of action, and until now we haven't had it conjoined, we haven't had to reach that issue of what's discoverable.
Well, I mean, certainly that's going to come up, and the statute
Correct.
doesn't address the bifurcation kind of thing.
Absolutely
it's
not.
Just totally silent on that.
Correct.
So it seems to me that that's really the issue that favors a plaintiff waiting, because you could get a lot of juicy bad stuff, possibly, that otherwise is going to be blocked until you decide the underlying dispute.
Right. And not only that, Your Honor, and this also gets back to part of Justice Pariente's question, the whole, the conjoining the breach of contract and the bad faith cause of action prejudiced us not only because of the $271,000, but because they were able to argue bad faith arguments in their contract case. So as we quoted in the briefs, both in opening and closing statement, they were able to argue that this case is not about how much is owed and how much the damages were. This case is about, as they say, delay and don't pay, make obstacles at every turn. They didn't return our calls. They didn't.
That's probably going to be talked about whether you're bifurcated or not, isn't it?
No, Your Honor, because those are bad faith kinds of issues and bad faith kinds of arguments.
Well, what was the issue in the underlying case was, before the jury, was how much, the extent of the damages?
Well, it was both, because
Well, but what would have flowed just from the breach of contract?
From the breach of contract is the extent of the damages, right.
And tell me again, the reason that this wasn't paid earlier was because there was a dispute about whether the deductible had to be satisfied first?
Correct.
Well, was that issue, was that a special interrogatory verdict in this case? That is, whether the deductible had to be paid first? Was that ever determined?
No, it wasn't that deductible had to be paid first. I may have misspoken. Whether the deductible had been met.
Well, the damages exceeded the deductible.
All right. So
Correct.
once the jury came up with the almost $8 million verdict, which is not, that's of the 5 questions, they didn't go on and ask us about that, so we're going to assume those are reasonable, then you would agree that this issue of, well, they didn't think it was worth more than $1 million, that it's a pretty good bad faith case at that point.
Well, Your Honor,
I mean, I don't want you to agree, but in other words, it has the makings of look what they did. They made us go out, do all these things. They delayed. And this case wasn't worth under the deductible. This was worth, 8 times the amount of the deductible.
Well, I have two answers to that. First, they asked for $11.5 million in damages. The jury gave them 7 point something for that part of the case. So they didn't get everything that they asked for. The second answer is that we submit that having the bad faith kinds of arguments in the case infected the jury's determination of what the damages were. So it's not just that you're doing these things together, it's that you're allowing one to bleed into the other. And as several courts have said, jaundiced the jury's view on the extent of the damages.
So, but the deductible in this case was around $1 million?
1.6.
Okay, and the actual damages that were awarded was in the $7 million range?
Yes.
And so basically your argument is if that bad faith portion had not been there, then that $7 million may have been less.
Correct. And just to give you a little bit of context, most of the dispute centered around the sliding glass windows and sliding glass doors and windows, which they alleged were damaged by the hurricane, and we claimed were not.
Would you address I'm troubled by the statute with regard to what the policy must contain facially.
Yes, sir.
And I do recognize that there's no separate particularized cause of action set forth in the statute, but certainly that statute has some meaning. And
yes,
although I understand you're saying substantial compliance, if we have statutes that require an insurance company to put something on the contract, and this is not unusual. I mean, we require certain signatures, certain sign-offs, and if it has no remedy, then it's a nothing. What is the remedy? Is there no remedy at all, or is it you're saying it's only regulatory? I'm having a hard time with that it means nothing to the individual insured if you don't comply with the statute.
Your Honor, there are administrative remedies. They can file a complaint with the Department of Insurance.
What good does that do the individual? I mean,
the statute allows the department under 624.310 parent 3 to issue cease and desist orders, which includes taking corrective action to remedy the effects of past improper conduct and assure future compliance.
Well, the whole purpose of this is so that people know. This happens to maybe be a sophisticated one, but the homeowner, I'm looking at this because that's still part of all the statutes, that a homeowner is supposed to be told in certain type that this deductible is higher. It's not within your normal deductible, and that's not on it at all.
Well, Your Honor, I think you have a good point there, but you don't have to reach that question. Let me tell you why.
Okay.
The certified question here is whether the failure to comply with the language and type size requirements makes it void or gives you a cause of action. It does not ask what happens if you don't have that at all. And I think that's a big difference that you can draw.
That substantial compliance here.
No, what I'm saying is maybe what if you don't have it at all? I mean, this is still in big type, and it contains things that the statute doesn't even require. It stands out from the other language on the rest of the page, which is not required by the statute. And there are some 18-point fonts that are smaller than some 16-point fonts. So we could have put an 18-point font in a type style that's very small and complied with the statute. If an insurer just doesn't put that provision in at all, okay, I think that is your concern, that the insurer doesn't have any notice. But there is no allegation in this case. There was no allegation or proof at trial that they did not have notice of the deductible.
Well, but the question is failure to comply with the language and type size.
Correct.
It doesn't say, because it seems to me that if we conclude that there is no private cause of action, I don't know how it would be different if they didn't have one in at all. If we read the statute as saying it doesn't, there's no intent to create a private cause of action, it wouldn't, whether it's substantial compliance or no compliance, it would be the same result. How would you parse that out?
All I'm saying is you don't need to.
But how would you then? You'd have to rephrase the question.
No. What I'm drawing a distinction is having a provision in there like we did but that doesn't comply with language and type size requirements versus not having it in at all. And that's what some of the cases have declared
But you
void.
know, in statutory construction, if we look at it and say, is a private cause of action implied, the same analysis is going to exist whether there is no, it's not in there at all or it's not there in compliance. Where would you get the cause of action from the one where it's not in there at all?
I'm really not addressing number 3 as much as number 4 about declaring it void.
Right.
So,
well, 3 is whether they can bring a claim,
right.
and you would say no, they can't bring a claim.
Correct.
So what I'm asking you is, how would you distinguish one where there isn't anything in there?
Well, as to number 3, I'm not sure you can distinguish it. The legislature has provided specific statutory violations that have a civil remedy. They're all laid out in 624.155.
So what would be the result then if, in fact, that insurance policy, rather than having it in a smaller type, although, bolded, had nothing in there at all that alerts the consumer? That's the real question. What then happens? The consumer still has no right to any kind of action against the insurance company.
Well, there's 2 answers to that. First, that's not a question you need to reach because it wasn't in the certified question.
But the thing is, it all goes together, right. Whether there's nothing or the type is 2 inches smaller or the type is 4 inches smaller than it should be. It all kind of works together, so the answer would
that goes to my second answer to your question, which is in answer to question number 4. Several courts, the cases that they cite, for example, the United States Fire versus Roberts, Geico versus Douglas, those are cases where the notice was not provided at all. It's not that the notice was in a smaller font. It wasn't there at all. And in those cases, the court said, well, that provision is void.
Void. So that's probably the answer, not a separate
cause of action,
but
correct.
You just don't. You can't enforce that provision because it occurs in surplus lines and all kinds of notification kinds of issues.
Yes, okay. But in a case like this, Your Honor, where it's right there. There's no question, no allegation that they didn't have notice. And by the way, just to give you some context, Justice Lewis, this is attached to the complaint, the policy, and this is on page 18 of 74. The first page of the exhibit to the complaint, the policy. 2 pages later, on page 20 of 74, is the deductible provision itself. It's an endorsement. And again, it's in boldface. And it says, this endorsement changes the policy. Please read it carefully. And then it says, Florida hurricane deductible residential risks. So,
and the exchange for that is they get a lower premium.
They get a much lower premium, yes. And they're told in here what the deductible is. It's all itemized for them so they know what it is. The deductible here was about 2% of the...
it's standard. I'm not sure you can buy a residential policy in Florida anymore without
correct.
that.
And that's negotiated, obviously, between the insurer and the insured.
Well, I don't think you want to go there.
Well, what I'm talking about negotiated means that for a higher deductible, the premium is lower.
Well, as a matter of fact, you can't buy a policy in Florida now without this larger deductible for those windstorms. Isn't that a fact?
Yes, it's a fact. But what I'm saying is...
Thank you for your candor.
No, but I'm saying it could be 2%, 4%. It could be larger, and the larger the deductible is, the smaller the premium can be. So that's what I'm talking about.
I appreciate that.
And so, in this case, to say that a $1.6 million deductible is void simply because what you can see very clearly is on there, but it wasn't an 18-point type. It was in 17.9-point type, which is where they want to go, I think is totally outside the realm of what the legislature intended.
And Mr. Quintero, you have a minute or so left if you want to save any time for rebuttal.
I will. Thank you, Your Honor.
Okay. Mr. Rogo.
May it please the Court, Bruce Rogo, Dan Rosenbaum for Chalfante. Let me clear away some of the debris here. This case involved Chalfante suffering terrible damage in Hurricane Wilma, which was in 2005. In the agreement, there was the promise by the insurance company that they would determine the value of the loss. The claim that we have for the implied breach of the covenant of good faith and fair dealing is they didn't do anything. How do you get to determine the value of the loss unless you take some steps? And they have discretion, because that's the language in the agreement. They'll determine the value of the loss. Their position is we can do it whenever we want. If your
Help me understand, Mr. Rogo. Why in the world would this insured not have filed a 624-155, a statutory basis?
Because there is no reason to have two lawsuits here. They filed the lawsuit to try to get reimbursed, to try to get paid for the damage that occurred to them, and they then added the implied breach of the...
Well, I understand that, but again, it comes back to the basic question. There's too much law out there that has discussed the issue, at least in the area of discussion, that Florida did not have a first-party type action against insurance carriers. So my question is there something different that's recoverable? That's what I'm looking to. How would it be different?
Well, two things, Justice Lewis. In Ruiz, which you wrote, and you quoted La Ferrette, I think it's important to understand, or at least this is the way I understand it, that the classic bad faith claim that we're talking about is where, and this is the language that the court used, that you used in Ruiz, Florida courts had refused to recognize the tort of first-party bad faith because the type of fiduciary duty that exists in third-party actions is not present in first-party actions, and the insurer is not exposing the incurred to excess liability. This situation is not the classic bad faith kind of claim in terms of what they wanted to do.
You're selectively reading parts of Ruiz. Ruiz does say that the statute was designed to require insurance carriers to deal fairly with their insureds.
It does, but the statute says to settle. It says
and
not
also,
attempting in good faith to settle claims. Settle claims.
Well, I think there's a little broader language in there than that.
Well, it does go on, but the point, in response to your question, what we wanted to determine was whether or not they had breached the contract in terms of not paying for the damage that had occurred. That's the threshold issue.
What does this add? What does this add other than suing them for what you say is due under the contract? They've breached the contract because the company has not paid what you say they owe.
And it added the ability to get from the company the $271,000 that was incurred.
Okay, so what you're saying is it would be the same items of damage as what we're talking about, is that it just was included here, not under a statutory remedy.
That's right. Then you'd have to have the second lawsuit. I mean, that seems to me to be something that it's the cause of action for breach of the implied covenant, because we're talking here a contractual term that gives discretion. If it gives discretion, then the contract is bound by the implied covenant of good faith and fair dealing. So rather than wait to finish this lawsuit and then sue them, 5 years later, because this case is already 5 years old, sue them 5 years later for $271,000?
Well, I don't think you have to wait. I don't think there's anything in the law that says that you have to wait and you cannot file a 155 at the same time you filed your complaint here.
Yes.
I just don't see that in the law.
Yes, but as they say, you couldn't try it.
I don't know that's the case.
Until you finish.
They may say that, but I don't know that's the case.
Well, I mean, that's the law that they're relying, and that's why I think it makes much more sense to do it the way we did it, which is to bring them all together. And, of course, what we have are federal courts, although they are split, finding yet this is so. You can do it this way.
Well, but
it seems to me that what Mr. Cantero was saying is that when you do it in this fashion, by bringing the breach of contract and the bad faith claim all in one proceeding, that you're really tainting the damages portion under the breach of contract because of all the supposedly bad dealings that the insurance company had with its insured, and that's one of the reasons you shouldn't bring these claims together.
Well, two things. First of all, I don't want to buy into and accept the notion that this is a, quote, bad faith claim. So, but I understand what he's saying, but this is a little different, or a lot different from a bad faith claim, and there was no prejudice here. And let me tell you, how do you avoid prejudice? The trial court takes care of it. The trial court can decide if the
It seems like we're slipping into not answering the first question, which is whether a common law there was a independent action for breach of dealing in good faith. Let's just say bad faith. And I haven't read each and every one of the cases that's been cited, but my understanding is that the whole reason that 624.155 went into effect is because there wasn't any common law remedy. So your attempt to say, well, I don't want to call it bad faith, I'd rather call it a lack of good faith, I mean, that's a little disingenuous. The issue is, what indication is there was a common law cause of action against your own insurance company for something other than breach of contract for damages owed at common law?
And because this is part of the breach of contract cause of action at common law. The implied covenant of good faith and fair dealing is part of that. And so
then it makes all of the case. So you're saying that really, if we look at every case that this court decided where we said there wasn't a cause of action at common law, it all was based on uninsured motorist coverage cases?
Not all of them, but most of them were, and that's where it started. Blanchard in those cases dealt with that. And it was because the insured was being exposed to excess liability because the insurance company wouldn't settle the case. And that's why I think the language in 155, which talks about settling, is important too. But there's always been a breach of contract claim, clearly. And so when you look at implied covenant of good faith and fair dealing, that's an aspect of the breach of contract claim, not the separate kind of tort claim that 155 sets out, because that's really what 155 is.
Let me ask you again, and I've looked at the briefs, read them carefully, I've listened to what you said, and I'm still struggling to understand how this cause of action that's implied is in substance different from the statutory cause of action that the legislature has established. And when I look at all this, it just seems to me that what I'm hearing is a distinction without a difference. I just don't see that there is a substantial difference between what these causes of actions are. And it seems that you're trying to supplant what the what the legislature has done and the strings that go along with that through this implied cause of action. Could you try to help me understand this distinction and what the real difference is?
The starting point for the real difference is that this is a contract claim, not a tort claim. I think that's a very important aspect of this, number one. Number two, there are no punitive damages that could be sought in this situation because this is strictly a contract claim. And 155 and that whole statutory scheme allows for the potential of punitive damages. It is a much different kind of claim, and it is wrapped up within the contract itself. Now, I understand 155 talks about good faith and fairness and honesty, but really the genesis for all of this was exposing the insured to excess liability. That's where it all started from. And so what I'm saying is that...
But that's in the third-party context.
That's right. But
this we're not talking about the third-party context.
No, but what happened, of course, was the insured would be exposed to excess liability if the insurance company did not settle the claim in good faith, and so there you'd have the situation that we're trying to avoid by focusing on under the contract must the insurance company, and this is the phrase, determine the value of the loss. And must it do it in a time that is timely so that there can be some agreement? Because the only three ways you collect on your insurance policy is either
But isn't that very thing something that is litigated in the statutory cause of action?
And this was Justice Lewis's question, couldn't you file it in the 155 action later on? And I'm saying, well, I guess you could do that, but that doesn't mean you can't do it this way, and that's what we're talking about.
But you could. The very thing you're litigating could be litigated under the statutory cause of action.
To the great detriment of the insured and to the great detriment of judicial economy, to the great detriment of public policy, where you'd have to have a separate lawsuit after the first one was litigated for $271,000.
But let's go back to what Justice Lewis said. And I'll look back at Ruiz. I think we were dealing then with the idea that there were concerns with work product. And we discussed that one way to deal with it is it's bifurcated. But I don't read anything we've said and anything in the statute that would say that they could not be filed at the same time, and then the judge makes a decision as to whether they'll go together or they'll be bifurcated. Am I missing something in our case law Mr. Rosenbaum's going to point out?
Mr. Rosenbaum says you need merits determination first before the 624 claim. But looking at it the way you're looking at it...
Are you saying that you cannot bring the 624 action before the coverage determination's been made?
That's what they are saying. That's what they are saying, that you have to do one first.
No,
That's
I thought they're saying that you cannot bring a common law cause of action. Then the next question is, if you can bring it, do you have to bifurcate it?
Well, and so if you can bring it either way, or even if it's only one way, and you can bring it there, then it doesn't have to be bifurcated in a situation where the court can control whether or not there's going to be any prejudice. That's our argument for bifurcation. The bifurcation argument is, well, if you try the contract claim as to how much you're entitled to receive for the damage that you've incurred, and then you get into whether or not they determine the loss properly or aggressively enough, you're going to somehow pollute that claim. But my response to that is, and this is why there needs to be no bifurcation, why the answer to question 2 clearly should be no, is because the trial judge decides if the evidence that's coming in is going to be prejudicial, if it's more probative than prejudicial. The arguments, the trial judge can control the arguments. The trial judge can control the discovery, and Ruiz was a discovery case.
Let's go. But when they're being tried together, I mean, what does the trial judge do? Say, well, this evidence is coming in, but this is only applicable to that portion of it? I mean, it's very difficult when you've got these claims that you're trying together, and if they should have been tried separately.
Well, not really in this situation, Justice Quince, because failing to determine the value of the loss is related to what the ultimate loss is. I mean, if I have a car accident and my adjuster says, in a couple of years I'll go check it out and see how much loss you have, well, by the time the value of the loss is determined, it's going to change the picture because rain or whatever it may be may have affected the car. So what I'm saying in this situation, we're talking about this case, these questions in this case, by not going out and determining the value of the loss, by taking the position as they did, whenever we get to it is fine. Judge Middlebrook said, you mean you can wait 5 years and then make a determination then, and maybe not? And he said that's the way it works.
Isn't that when you bring your breach of contract case?
Well,
when they haven't adjusted the loss?
And we brought the breach of contract case. But
going back to this distinction, I hate it because if we don't get the first question answered correctly, this issue of bifurcation either becomes important or it becomes moot in this situation. What I'm having trouble with is understanding how, if at common law we didn't allow a cause of action against an insurance company who had uninsured motorist coverage, for the person, and they didn't pay promptly, and the person was exposed to excess liability or underinsured motorists, and they couldn't get their own coverage because the insurance company was stalling. That's as much an implied breach of duty to deal in fairly as the one of saying, well, you didn't, you're disagreeing on the value of the loss. So your idea that we could somehow pick and choose which would be the actions understood at common law and which are only 624 causes of action, it seems to me if we were going to recognize any kind of implied duty, it would be in the classic first-party bad faith case, and we never did. So do you understand my concern is that you're saying, well, this one should have been, this is an implied breach, but those others where they just ignore how much the value of the claim was and just don't pay anything or don't pay timely, no, those would have to go through 624. I don't understand that distinction that you're making.
The distinction...
I understand it in terms of this was this case and that's that case, but in a meaningfully legal context or in fairness to all insureds.
I think the starting point is there was always a breach of contract cause of action that an insured had. And I think everyone will agree with that, a common law cause of action. This is just an aspect of that common law cause of action. And it deals with the situation that this case focuses upon if the insurance company has discretion as to when it's going to determine the loss, it's got to exercise that discretion in a way consistent with the covenant of good faith and fair dealing. And they talk about, well, that means reasonable expectations, and reasonable expectations don't come into play in insurance.
Well, how is it different if I have been struck by an uninsured motorist and I am severely injured and my insurance company doesn't pay my $100,000 in uninsured motorist coverage?
And in those cases, Blanchard, in those cases, you have to litigate first whether or not...
No, but it's still, the question is, whether you now you're going to the second issue. Why wouldn't I have as much of a common law breach of implied contract action as in this situation?
And you would, but does that mean that you cannot bring that cause of action in the case, your breach of contract case? I mean, I'm not sure I'm following your...
Well, I thought the first question was, do we recognize a common law action for either bad faith or lack of good faith in the dealings between an insurance company who has is owing first-party benefits? And I thought, again, and this is where we started from, the law was there wasn't a common law cause of action, which is why 624.155 came into being, to give insureds in first-party context that kind of protection.
For bad faith, that's right. And see, I think that's an important distinction. There is a difference here between bad faith and good faith and fair dealing within the contract.
Let's change the example.
Okay.
Let's change it to individual medical benefits. There's never, to my knowledge, a Florida case that's permitted a separate cause of action, separate from just for the benefits, for payment individual. I know the employee stuff's now all federal court and you have no rights, but individually. Because those were attempted and never allowed to proceed historically in Florida law. And it's not an automobile. It is a first-party benefit situation. Is there a case, a district court case level in Florida, I know there's none of our cases, that ever allowed that type of claim for damages?
I am not aware.
Well, that's the point we get to, because that's where this seems to stem from, is that Florida courts, it may not have been the precise holding on the precise facts, but I mean certainly a recognition that we never allowed one of those. I mean, to the chagrin of many, many people, but that's just happened to be what the status of Florida law was. In the insurance context.
Yes. And, I've made my point. I've made it in the brief. I've made it here as best as I can make it. And I want to address a couple of other things. One, the must contain provision on the deductible. Well, clearly it must have some force. And the cases have talked about an insured must clearly know what is being covered. And there's a difference between a windstorm and a hurricane. I mean, a windstorm, you can have a thunderstorm, and the windstorm can raise the roof of my house and you'd have damage. And so that's an important distinction. It's not just the 18-point versus a 16-point. It is a mandatory statutory language, must contain. It doesn't contain it. What is the remedy for it? I think question 3 is not quite the proper question. The question is whether or not there's an independent cause of action for that. I think what we're talking about is there a remedy? And that's really what we're talking about, for failure to comply with that. And if the remedy for failure to comply with that is nothing, well, then the statute has no meaning. And so I think in this situation, the deductible cannot be applied. And whether or not you raise that issue after you get the judgment, and then the insurance company says, okay, now offset the deductible, and you say, no, you can't offset the deductible because you didn't comply with the mandatory aspect of the statute. So that's on that. Entry of judgment, this is an interesting one. Of course, it interests me. Payment within 30 days upon entry of a final judgment. That's the language, the plain language of the contract. And they're saying, that means when it's all over.
Let me ask you about plain language. Is that really plain language, or you're really relying on that term as a term of art?
The plain language in their contract is they will pay upon... But
I'm talking about final judgment. Are you relying on the understanding of that as a term of art, or the plain language understanding of that?
On both. I mean,
Do you think they're equivalent?
I think they are in this situation. Lawyers who practice know that entry of a final judgment is when that trial court enters a final judgment. That's the time from which it's appealable. It can only mean one thing, and they certainly could have written it a different way.
But in the context of final judgment, I mean, if you're appealing it, is the judgment really final? Because it can be changed on appeal.
And Silverstone, of course, talks about, and that's the lawyer malpractice case, statute of limitations runs from when it's final, the way you've described it, Justice Quince. But that's a much different situation than this, because it is a final judgment. That's their language, entry of a final judgment. It means something.
That's whose language?
That's the insurance company's language. They included that language, pay within 30 days of entry of a final judgment. And if the concern is, well, sure, we want to take it up on appeal, and if we've already paid the judgment, what happens? Well, if they win on appeal, then they can file a suit for unjust enrichment, try to recoup the money, put a lien on the property, record the judgment. But they have chosen that language. They are hoisted on the petard of the language that they chose, and that's the only meaning, entry of a final judgment. And the fact that there is supersedious available, they could have written in the contract upon entry of a final judgment, or if superseded, or if appealed, when all the appellate processes are over. They could easily have done that. They didn't do that. So that language, I think, means that the last question must be answered in our favor. So our position on this simply is, first question should be answered yes, that there is an implied covenant of good faith and fair dealing that can be brought in the lawsuit, the original lawsuit. 2, there's no reason to bifurcate it. If there's any concern about prejudice, that's a matter that can be taken care of with trial court evidentiary rulings. 3, that failure to comply with the notice provisions, the must-contain notice provisions, means you can't apply the deductible. And 4, entry of a final judgment payment means just what it says. Thank you.
Thank you very much. Mr. Quintero.
Thank you, Your Honor. I know I only have a minute. I'd like to address the final judgment issue first. And certainly by saying final judgment, you can't say that an insurance company knowingly and voluntarily waives its right to post a supersedious bond and essentially waive its right to an appeal, because we all know once you pay out the judgment, it's going to be extremely difficult, if not impossible, to get back. That's the whole purpose of a supersedious bond. The bond essentially guarantees the judgment. So if that appeal is affirmed, the insured is absolutely protected. If there's no bond posted, then they can execute on the bond.
When does the judgment become final?
According to Silverstone, either upon the expiration of the time for appeal, or if there is an appeal, upon the expiration of the time for motion for rehearing or the determination of that motion for rehearing.
And then Mr. Quintero, I mean, you do follow, the strict construction of the language. This one says final judgment.
It says final judgment, Your Honor, but final judgment, judgment is not final until appeals are exhausted. And in the few moments I have left, let me just say this provision has been around for a long time. No court in the country has ever said, no court ever has said that this provision waives your right to post a supersedious bond, essentially waives the right to an appeal. Thank you for your time.
Okay. Thank you both for your arguments. The final case on the court's calendar for today is Osborne versus Dumoulin. Interesting names.
May it please the court, my name is Les Osborne. I am the appellant in this case. With me at the council table is Tarek Kane. Your Honor, this is our appeal from the certified question in the 11th Circuit. The question dealing with Florida Statute 222.254. The question the 11th Circuit brought up was, what does it mean? If a person does not claim a homestead and it indicates an intent to surrender their home, is that enough to give them the extra personal property exemption of 222.254? I would assert that the answer to that question must be no.
Well, explain this. How are they receiving the benefit of the homestead if they're surrendering the homestead?
Well, Your Honor, I think, number one, we are interchanging the words surrender and abandon. And what I would suggest is that the cases that have come before this court going back years to Hutchinson Shoe in 1930, this court pointed out homestead is self-effectuating. When you own a home, when you live on that home, it becomes your homestead and you are automatically entitled to the homestead protections of the Constitution. Nothing further need be done. You need make no statement. You need to take no further act. You are protected under the Constitution. You have received the homestead benefits, protection from your creditors, inuring to your descendants in this case. What ends up happening here is what we're having is the statement of intention is a bankruptcy form where somebody just says, I intend to do something. Now, I intend to be President of the United States. Doesn't make me President of the United States. It's just something that maybe I intend to be someday.
So you're saying that has no legal effect? That would not have any estoppel
no
effect?
Legal effect at all. And the reason I would say that is because this court has long held what is required for abandonment. This is one of the first times in history I think we've had debtors actually arguing that their homestead is not their homestead. Usually it's the other way around. Creditors are arguing that it is not their homestead. But there are several standard tests that need to be met. In order to abandon your homestead under the law, you have to actually leave the property with no intention of returning and indicate an intention that you're no longer going to have this as your homestead. Saying that I intend to surrender might meet the first obligation, and that's how the courts have looked at it, the bankruptcy courts where this has come up, saying, well, we intend to surrender, we're taking that as your statement of intention. But they're not actually doing it.
But are you saying that under the situation that we would have in a given case is that once the person elects to take the debtor exemption of $4,000, that they could also go back and get their homestead exemption for bankruptcy purposes? In other words, get both in some way?
I'm saying that that's exactly what's happening, Judge. In this particular case is a good example. The debtor filed...
But again, if there's a situation, though, where... and we're not bankruptcy experts here. We're asked to interpret a statute as to what received the benefits, what that means. If, in fact, the election is made, and it is made in a way that they cannot, for bankruptcy purposes, reassert it, then isn't that, can that be done in bankruptcy, where you take the $4,000 and you give up your right to claim the homestead exemption?
Yes and no. Again, I don't mean to not directly answer the question, but that's almost what happened here. When the case was filed, the debtor actually claimed the homestead.
Because she thought it was going to be a sale.
Exactly. She thought she'd sell it to a friendly purchaser and get it back. Under the bankruptcy rules, after the creditors meeting, which happened on October 26th.
But if that had happened, if she had gotten if she had sold it, then the creditors would have gotten whatever. I mean, it's not like she would have been able to retain the proceeds.
Yes, she would, Judge, because she claimed it exempt just for that purpose. If she would have gotten the proceeds, those were her proceeds. When that fell through, she changed her mind. But I believe that is, again, somewhat of a red herring, because in this case, again, the debtor received the benefits of the homestead. Let's forget the bankruptcy exists for a moment. The day before she filed bankruptcy, when she filed in September, the day before, it was her home. She was residing there. It was protected from her creditors. This court has long held this, in as many cases said, the homestead is sacrosanct, or as one court put it, the sacred cow. We protect that in Florida above all else for the benefit of the health and well-being of the family. This debtor had that.
Were you saying anybody who ever had a homestead, or had a homestead right before somebody's trying to execute on their assets is never going to get the benefit of this $4,000?
Yes, Judge, that's exactly what I'm saying.
Okay.
If you've got that homestead benefit,
did she file an amended petition?
Yes, Judge.
And she took the exemption off the homestead and claimed the $4,000.
Yes, but
so she's given up her right to benefit from homestead.
I would argue two reasons where that is not the case.
I'm talking in this case.
In this case, Judge,
okay.
Two reasons. Reason number one, the debtor initially claimed the homestead. Under the bankruptcy rules, from the time of the creditor's meeting, any creditor or the trustee has 30 days to object to that exemption. Otherwise, it is automatically allowed by law, and the United States Supreme Court has said nobody can ever come back and challenge it again. That 30 days is 30 days. Her amendment was more than 30 days. So she had claimed it. She had successfully defended that claim of homestead against her creditors and the trustee, which is something that was brought up in Judge Jordan's opinion in the lower court, the district court, in quoting Judge Mark. So, number one, she had actually already obtained that benefit from day one.
And then she waived it.
Then
you said you can't waive it once she claimed it?
Yes. You could then technically say, I'm waiving that exemption because now I want the $4,000.
And that was manifested by filing the amended petition?
Filing the amendment. Okay. I never could have challenged it. Creditors never could have challenged it. She could. But that brings us to the second issue.
But isn't the purpose of homestead to protect the owner of the home?
Yes, Your Honor. And the
homeowner does not want to be protected. You're using the shield as a sword.
That is my point, Judge. That's exactly what she has done. She has used the shield as a sword.
But why under this scheme shouldn't she be able to choose between which she's going to benefit more from? The homestead or the $4,000. If she's going to do better with the $4,000, she can waive the homestead.
At what point?
What's wrong with that?
Well, Florida law doesn't really even allow you to waive the homestead. You have to alienate it or abandon it.
Well, however, if it is an affirmative waiver, I mean, through alienation or abandonment or the standard you're suggesting, why can't she do that?
Your Honor,
and then get the benefit of the $4,000?
Had she actually done that, I would agree with you. Had she actually abandoned the property, then yes, she would be entitled to it, but she didn't.
What more did she need to do? In this case, she amended the bankruptcy petition. She says that she was not going to contest the foreclosure.
Correct.
So what more did she need to do in order to demonstrate that she had abandoned the homestead?
Well, Your Honor, first of all, even though she said that, initially she didn't. Initially, she claimed it. She said, I want the homestead.
I'm talking about from the point where she actually amended it, said, I'm no longer claiming the homestead, I am I'm giving up my interest in this property. What more does she need to do in order to satisfy what you claim would demonstrate abandonment?
The simple two-step test. Statement, show the subjective intent that she's going to abandon. Yes, she says, I'm going to abandon. She would have met that part. Then number two, the objective test. Relinquish the property. She didn't do that.
You know what it sounds like that we're dealing with here is a problem with the rules, the bankruptcy rules, and not our statute so much. Because, correct me if I'm wrong, but it's my impression that there's Florida law, and maybe arising out of old bankruptcy cases, that you can sell your homestead, and the proceeds of that sale remain homestead for a reasonable period of time.
Absolutely. In fact, even the Orange Brevard case cited by this court, the homestead for as long as you intend to invest in a new homestead. Right. Correct.
So, I mean, this is what it sounds to be, though, is that then at some point, if you don't, a creditor would have a remedy. But this is a problem created by bankruptcy rules, not Florida law.
I don't think so, Judge. Well, I think the issue of that, I think we're getting off to the amendment issue, which I don't think is really the issue. That's where I think is the red herring. I think the issue is the benefits language, and when do you receive the benefits? The statute and many of the cases talk about it's a present tense statute, meaning he received the benefit at the time. So in this case, because of the bankruptcy, the date is fixed and the date of filing. And again, forgetting the amendment.
Help me explain exactly what benefit she has received from the homestead exemption.
The benefit she receives is a constitutional exemption where it is protected from creditors.
Well, I understand that, but what I'm talking about in this case, what benefit has she received from the existence of the homestead exemption?
And again, maybe I'm not understanding your question, Your Honor, but to me, the benefit she received under the Constitution is the protection from creditors. Her heirs are protected from creditors.
But in bankruptcy, isn't what, I mean, the reason this is here is because I guess ever since the statute is passed, the bankruptcy judges have tried to figure out if this language should be given a broad or a narrow reading. Judge Hyman has said that it's concluded the exclusion should only apply if the debtor asserts the homestead exemption as against the forced sale of the homestead, meaning that if the creditors can reach the homestead, the person hasn't received the benefit of the homestead exemption. And again, this is not my area, but it just seems to me that you are arguing that if, I think you said it to Justice Kennedy, that if they had once been a homestead property, that it is, you never can get this $4,000 credit, that it is only for people that have never had a homestead, renters or people that have not claimed homesteads. That's what we're dealing with, is whether we give this, or is that correct, a broad or a narrow meaning, the statute that is passed by the Florida legislature to give some relief to debtors.
And I believe you're giving it in this particular, I shouldn't say in this particular instance, it should be given somewhat of a narrow reading just in this circumstance.
But do you agree that's the dispute? You're now saying why it should be given a narrow reading. What I'm suggesting is, again, without getting into the nuances of bankruptcy law, that if we accept the position of the business law section and also the at least the view of one of the judges in the bankruptcy court, that receiving the benefits is if you are able to successfully defend your homestead against forced sale during bankruptcy. Am I missing something about what else? She can't claim both things. She can't get a $4,000 exemption on personal property, plus get the benefit of her homestead.
Correct. They are mutually exclusive.
Okay, but that's what I thought I asked you earlier. I said she can't do both. So that's where the equity comes in, and with the intent. If you waive one, you can claim the benefits of the $4,000.
If it's more than just saying I have the intent. Because that's where the real problem is, what we've been having in these cases.
Now, the way bankruptcy works, as I understand it, that the bankruptcy trustee wants to marshal the assets to satisfy the creditors.
Correct.
Now, one of the things that was exempt was the homestead property. It's automatically exempt unless and until you don't claim it. And she did not claim it by filing the amendment saying that she was no longer claiming homestead. So therefore, the homestead property would go to the trustee, would it not? And she could not receive any benefit from it because it's in the trustee's estate.
That's then the difference between the claiming the exemption and the actual administration. But that's not what I think the issue is here.
Okay. I don't understand the issue.
Why not? That sounds like a perfect, the question that was asked seems like to encapsulate the issue, what the issue really is, perfectly. So why is that not the issue? If you can get your hands on it.
Well, Judge, but the first part is I couldn't get my hands on it.
Okay, well, explain that to me.
Well, first, as I said, she claimed it exempt. Okay, she claimed it exempt.
I understand at that point.
Objecting passed.
Well, see, that's the point. This is a bankruptcy rule problem.
Well,
again, it comes down to you've got a period of time in which to do something, right? And so she changed her mind after that period of time expired. So it's a bankruptcy rule that creates the problem, not the Florida statutory provision.
I would suggest, Your Honor, it comes up mostly in the bankruptcy setting because this is where we deal with these $4,000 issues over and over and over.
But it could be just a normal creditor not in bankruptcy.
I would suggest if we ignore the bankruptcy for a moment and we just look at Florida law and what the Florida law has been going back years and years and years. Homestead comes first. Homestead has always come first. That's why I said earlier that normally when you're dealing with exemptions, we want a broad interpretation of the rule to give the benefit of the exemption as much as possible to the parties seeking it. However, when that rule is directly conflicting with the homestead benefit, the homestead, which this court has always said is the most important of those rules, the homestead has to be given the broadest interpretation and the benefit therein. And the limited, this is where we we more narrowly construe this particular statute in conjunction with reading it in relation to the homestead. The homestead benefit has and always should come first. The 4,000 is a secondary statute, which is, again, a statute as opposed to a constitution.
Well, it comes first if she wants it. If she doesn't want it, then she no longer has it.
But then at what point...
And then she's eligible for the $4,000.
That brings us back to at what point do we make that determination?
Well, you're saying the 30 days, that again, going back to bankruptcy rules, that after that period expires, she can't give it up. That's where you're going with this.
That's where I'm saying she'd already made the claim at that point. So that deals with the first section, really. I'm saying that she received the benefits under this court's rulings, under the Constitution, prior to her ever filing bankruptcy. She had it, and up to the day and the minute she filed. Nothing by her filing bankruptcy waived or abandoned the homestead, and that protection and that benefit stood.
Help me understand again why you can't get your hands on the homestead. Is the homestead worth anything?
No.
Is that the underlying problem here, that it's not worth anything?
That's where this has been coming up a lot, honestly, Judge.
Well, okay. Well, I can understand. I mean, if it's not worth anything, then it seems like to me the benefit she's getting from the homestead exemption is not worth a whole lot.
But if the people are keeping their homestead, they're still living there. They're saying, well, there's no equity now because we're currently in a down market. So therefore, nobody can sell it because they know a trustee can't sell a property because they have to get enough money for the unsecureds. But they get to hold on to it. They get to keep reaping that benefit as the equity goes back up. Again, they get it there.
But it's a very tenuous kind of benefit.
Cannot the trustee evict her if he wanted to?
I'm sorry?
The trustee could evict her if he wanted to because it's his property now. He's like any other landlord.
Not a landlord, it would actually be.
Well, I know, but...
Yes, Your Honor, it's a lot more
analogous.
Through the bankruptcy system.
Right, I know. I used to be a bankruptcy trustee. I understand how it works.
Justice Poston has a question for you.
I apologize.
That's all right. In the Magulitz case, Judge Killian held that in order for a debtor who has an interest in a homestead to claim the 4,000 personal property exemption under Florida Statute 222-254, the debtor must, 1, not claim the property as exempt, and 2, timely and properly show a clear and unambiguous intent to abandon the property. Do you agree with that holding?
Yes, Judge, that's exactly what I've been saying. They need to give that intent and show they're abandoning and actually abandon.
Well, then that seems inconsistent with your answer to the certified question. Could you explain how
because
that's
the certified question simply uses the word intent. If they give an intent, that's only half of the test that this court has set forward. Intent plus actually giving up the property. Saying I'm going to do something doesn't make it so. I intend to...
agree with this holding is the implementation of that. In this case, it gives you...
I would say you can't claim it. You must say I intend to give it up, and then you must actually give it up.
So are you actually saying as long as she still lived in the property, as long as it had not been taken from her in the foreclosure action, that she was still reaping the benefit of the homestead exemption?
Yes, Your Honor. Using the perfect example, had she gone through with her sale, had the property values gone up during that time period, she could have turned around. She wasn't going to turn around and say, well, I made an extra $10,000, $20,000. I'll give that to my trustee. No, she's keeping it. She received the benefit.
Well, but let me, again, I apologize for having trouble understanding this, but now, you can take the homestead. You can, in these circumstances, tell me if I'm wrong, are you precluded from getting access to the homestead and administering that as part of the bankruptcy estate?
I was precluded until
at one point. I understand that. But once she said, "I don't want it," I expressed my intention to surrender it. At that point, are you precluded from taking that in as part of the bankruptcy estate?
At that point, I could, Your Honor, technically.
But economically, it doesn't make sense for you to do that.
Correct.
Okay, so that's what this is about. Okay.
Well, that's.
But you can do it. You just don't. It's economically. It doesn't. You don't. The calculation you made is that doesn't make sense.
At that point, 4 or 5 months later, after the debtor has lived there and received the benefit, which I assert is receiving the benefit, living, retaining your home, protecting your home from creditors, all of which she did, until such time as she decided down the road that wasn't in my best interest anymore. So then she's now used the shield of the homestead and then turned around and used it as a sword to get the extra $4,000.
I think we understand your argument.
Thank you.
Madam Chief Justice, good morning. I'm Patrick Scott. With me is my colleague Jeffrey Kunst, and also here from the Florida Business Law section is Elise Homer.
I'm sure are you proceeding pro bono in this case?
I am. Pro bono and
so if you could help the court. What was that?
Pro bono and post-mortem.
If you could give the court a benefit of what are the overriding policy issues that that brings a firm like yours into this, as to what we're really faced with in this particular with this statute.
I am generally, by the way, a trustee's lawyer, and the business law section of the Florida Bar is generally not regarded as a consumerist organization, I would say. But tens of thousands of debtors have been given an opportunity by the 2007 legislature to receive an increase in the 1868 exemption that was given to all Floridians for personal property. That $1,000 exemption has dropped to $70 in value today, using $1868. But in the course of proposing that legislation from the business law section, whatever caused this perception, the perception was that there had to be a balance of some kind. Not all Floridians would get the extra $4,000. So the extra $4,000 was given to those who neither claimed nor received the benefits. Claim really doesn't have an ambiguous meaning at all, and we suggest that the phrase "receive the benefits" ought to be interpreted narrowly, because it's neither claims nor receives. If the exemption statute is to be interpreted liberally, as has been this court's policy, for the benefit of the public interest that they represent, then the exception, receiving the benefits, should be interpreted narrowly. And courts are deeply divided. 14 Florida federal judges have published opinions on this issue in 2.5 years. Both district court judges who have published opinions have come to the conclusion that we suggest, which is that perhaps the homestead, it's receiving shelter from rain, it's receiving the potential for appreciation, receiving a discount under Article 7 of the Constitution from real estate taxes.
But if you are actually living there and this is your only residence, aren't you also receiving the benefit of the homestead exemption? When you get your tax notice, your adjusted value, or whatever you call it, is going to be reduced by that $25,000 or $50,000 or whatever it is now. And so you are, in fact, receiving the benefit of the homestead exemption also, aren't you?
You are receiving the benefits of the Article 7 homestead exemption. The statute is clear that it's the Article 10 homestead exemption that is being questioned. Are you receiving the benefits of the Article 10 homestead exemption?
Which is the exemption from forced sale?
From levy and forced sale, and the exemption from bankruptcy.
So that, I was on the next page. The statute says the benefits of the homestead exemption under Section 4, Article 10. So
yes,
is that's significant then for the interpretation that it is only the benefit from forced sale that you are that is at issue as to whether you get the $4,000. Is that your interpretation?
It is, and other lines can be drawn, and some of the courts that have published decisions have drawn other lines. Some have said that if you state an intention to surrender, which is a bankruptcy form that in no way relates in any way to whether something is property of the estate, is exempt from the estate, enters or leaves the estate. It's an intent as to whether you're going to oppose stay relief or whether you're going to oppose foreclosure by a secured party, someone who's not affected by the homestead exemption, somebody who's not prevented from forced levy. The position of Ms. Dumoulin has been, and the position of the courts that we've cited, has been that once you accept or take the benefits of the homestead exemption, after making the declaration that prevented the restraint, or without ever making a declaration that restrained creditors from you, if you accept those benefits, if you receive those benefits, you're not entitled to $4,000 personal property.
What would be the benefit?
The benefit stated in Article 10. The benefit is the restraint from forced levy, and under the bankruptcy law, that same benefit applies in bankruptcy cases. She's not receiving that benefit, and frankly, no one's receiving that benefit who doesn't create an obstacle.
So the certified question uses the word, indicates an intent to surrender the property. Is that a bankruptcy term?
It is, and it's a very narrow certified question when asked that way. It doesn't really respond to the 12 judges who've issued opinions on this, or the 12 bankruptcy judges and 2 district judges. It's just asking if she filed a particular paper in the bankruptcy court, is that enough to show that she's entitled to the $4,000 exemption? Answering that, unfortunately, we hope that you will broaden the question, because it doesn't really resolve the bigger controversy, which is what is receiving the benefit. And while the line can be drawn in a lot of places, Mr. Osborne draws the line, for example, that if you remain in the home, you receive the benefit. And he uses it in the sense that 3 bankruptcy judges have used it, which is the potentiality for a benefit in the future after you come out of bankruptcy.
So let me ask you this before you get too far afield. We were talking about the actual certified question, which is about the intent to surrender the property. And what would be your answer to just that certified question? I know you want it to be broadened, but what is your answer to just that certified question?
In this certified question, we believe that it's irrelevant whether she stated the intent to surrender or not, because it's possible to state the intent to surrender, but to benefit from the homestead exemption. An example is given by Judge Mark in his Hernandez case, and it's the same example given in our brief and in the amicus brief, which is a debtor who's married files a loan. His wife doesn't file bankruptcy. They own the property tenancy by the entireties, but it would have been administered for the benefit of joint creditors. It's a common situation in bankruptcy court. The wife, who is not filing bankruptcy, has not disclaimed the homestead exemption. She actually is an obstacle to the bankruptcy estate realizing the property, and she would be an obstacle in the same context if you were outside of bankruptcy and applying this in a forced levy situation. The debtor is receiving the benefit of the homestead exemption, curiously enough, not his own, but his spouse's. That is the example given by the amicus brief of the business law section as to why those words were put into the statute that don't naturally flow. They're not words you naturally see in statutes. It receives the benefits. Because if the debtor presents no obstacle, if the claim of exemption or the continued residency presents no restraint, then the only benefit provided by Article 10, Section 4 is unavailing to the debtor.
So how would you reword this certified question?
I think the question, Your Honor, really is best stated as if a debtor presents and receives no uses no obstacle to the levying creditor outside of bankruptcy or to the bankruptcy trustee inside of bankruptcy, is she receiving the benefits of the homestead exemption? There's no question here. She's not claiming the benefits of the homestead exemption. I should point out, because someone asked about changing the claim of exemption, the bankruptcy rules provide for changing claims of exemption up until the case is closed, but the limit is that the court can control it by determining whether the change was in bad faith or prejudiced another party. Another party relied on it to his detriment. Mr. Osborne had an additional 30 days when she amended to object. He did.
Well, that's what he seems to be saying, is that this was amended and changed to the detriment. But I mean, that's what this whole argument seemed to me to be based on that.
Yeah, but he didn't suffer any detriment because he didn't act in reliance. That's what prejudice would mean in this context. He acted in reliance upon it.
Well, and the fact is that if he wanted the homestead, he could take it, right?
He could. The 11th Circuit has actually stated that they're past the issue of the change in exemption. It continues to be talked about in the briefs, but they actually acknowledged that there was an appearance in the bankruptcy district court that there was no prejudice, there was no bad faith. There are situations that come up where a debtor, for example, is found in bad faith, changes exemption because he wants to include a property he concealed from the court originally. And he's denied that change in exemption for the very reason that he has acted in bad faith. There are controls, by the way, in the forced levy context, too. If a debtor uses the procedures in Chapter 222 of Florida statutes to designate or set aside a homestead, there's a procedure for doing it in the public records before there's a levy. There's a procedure for doing it after the levy. If a debtor chooses to do that, that may well be, in the state court context, a claim of homestead. And it may well be also that that if he withdraws that after having initially claimed it, that there will be a bad faith control of some kind. The court will look at principles that would stop that person who withdraws the claim from doing something that challenges the integrity of the justice system or that adversely affects another party who relied to his detriment upon the original claim. That didn't happen here. He had an extra 30 days to object. He did object. He had the trustee had his opportunity to take it through the court system.
Well, they seem to say that if there is this, like she had the car, I mean, she's now deceased. They have the car, so now she's going, that's what the bankruptcy trustee was trying to claim, the car. She then says, okay, that's exempt, that $4,000 car or whatever it's worth. And then she takes that car and she sells that car and takes the proceeds. Can she come in thereafter and repudiate her intent to surrender and not to claim the homestead? I think that was the trustee's concern, is that we don't want to unduly punish someone, but we don't want to put somebody in a position to take advantage of both the homestead and the exemption. So how would that work?
One of the courts, I don't recall which in the opinions that we cited, actually found that the debtor changed her exemption too late in the case and that she'd be deprived of that opportunity because she changed it so late in the case that, for example, she had already received her discharge. And, for example, she had already put the trustee through the full administration of the case, and the administration of the case was completed, and then she went back and sought to change it. To me, it's a case-specific scenario that's controlled by the trial judge, and I can't really speak on how you could work something into a rule. I just know that if you apply this other rule, you've turned if you apply Mr. Osborne's rule, you've turned it into a renter's exemption. Well, the person who owns a home doesn't get the...
I'm not that familiar with bankruptcy law, but this property was in foreclosure.
Yes.
Correct. And with her saying, I'm not claiming that exemption, the trustee can still take the property even though it's in foreclosure. Is that correct?
He owned it. He owned it from the time she claimed it non-exempt. He owned it, and he continued to own it until one day he actually filed a notice of abandonment.
So there's no way that the debtor could have somehow negotiated with the foreclosure people and got down the mortgage to a point where she could now afford it and continue to stay there. So because it's now technically the trustee's property. Is that correct?
It is, but conceivably, after Mr. Osborne determined that it was valueless to the estate and abandoned it, she might have found herself in a position where the bank's view of the practicality was that they would go back and make new terms with her. It's not impossible that she could get to keep this property, but she didn't impair a creditor or a trustee from obtaining the property by doing that. It's conceivable that could happen. It didn't happen in this case, but it's conceivable.
Do you agree with Judge Killian's holding in the Maguilet's case?
No. Because Judge Killian suggests that if you don't indicate an intent to surrender, or if you indicate an intent to surrender untimely, or if you, I think he would go so far as to say that if you indicate an intent to surrender and don't perform it, I think he would say in any of those three circumstances, you don't get the exemption. And in fact, the intent to surrender just isn't a concept that relates to exemption at all. Intent to surrender, in Judge Killian's opinion, relates to the state of mind of the debtor and whether she's going to receive the future potential benefit. But the choice of the words "receives the benefit" has two components to it. The benefit must be actual, and it must be economic, according to the House of Representatives staff analysis on this bill.
Now, which is, of all the bankruptcy judges, is there one opinion that you think most closely reasons it in a logical fashion that gives meaning to the exemption?
Yes. Chief Judge Hyman's Abbott opinion from the Southern District. I think it says pretty much what we say. Not the only reason I agree with it, of course. He is our chief judge.
Does he get double points for that?
I wanted to hit on just a couple of things that Mr. Osborne said.
One thing I want to ask, because we are interpreting the legislative intent of this legislature, how far can they? I mean, if the business law section said, we didn't really word this as well as we could have, look what we just did, 15, they're just creating havoc. Could, if the legislature wanted to say that living in a home during foreclosure is not receiving the benefits, would there be any bar in federal bankruptcy? In other words, is this area preempted, or it is subject to what the state law is on it?
Absolutely. There's no preemption of any state exemption law.
So if our state, if what you're saying is this idea that we want to let, even if people are in bankruptcy, that it's better to let them at least stay in their homes while all this is going on, and still receive a $4,000 credit. I mean, that you're saying that actually was what you understand to be the intent.
And these are the people who it affects, the people who are remaining in a home while offering it to their trustee, are receiving no present benefits, but a situation could be conceived where they could in the future receive a benefit. It's an unusual situation. It wouldn't affect very many of the people who Mr. Osborne would affect. But they could receive a benefit in the future, but they're not receiving the benefit now. And if they seek to receive the benefit in the future, if that strange alignment of stars came about, that they could actually preserve their home, the trustee doesn't want it, he abandons it, they preserve it, they go on life after bankruptcy, a new debt is incurred, the new creditor levies and seeks a forced sale, and this debtor wants at that point to receive the benefit and asserts the homestead exemption as a bar, they don't get $4,000 in property.
So this issue really fueled by the fact that there are probably a lot more people in bankruptcy who are in foreclosure, or homes are not worth as much as their mortgage is, and those kinds of things?
I'm sure it's a frustrating situation for trustees whose duty it is to maximize the property, but they don't want to ask the debtor to leave. They've been offered the property by the debtor because the debtor wants to save, in this case, an old Chrysler. And they don't want the property because the trustee knows the property won't actually produce any recovery for the bankruptcy estate. But they also don't want the debtor to leave because that doesn't produce any recovery for the bankruptcy estate either. They really want the debtor to have neither exemption, because that $4,000 is more meaningful to the bankruptcy estate just as it's more meaningful to the debtor.
How would you answer the certified question as currently phrased?
The certified question is phrased, which is, if a debtor states an intent to surrender and does not claim the exemption, does that debtor receive the benefit? It's difficult to answer because it's not asking the question about whether the debtor is using the exemption as a bar or a restraint against creditors. Ordinarily, a debtor who states an intent to surrender, as Ms. Dumoulin did from the beginning.
Well, now, actually, here's the question, so we know what we're talking about. Whether a debtor who elects not to claim a homestead exemption and indicates an intent to surrender the property is entitled to the additional exemptions for personal property.
Well, she is always entitled in that circumstance.
So your answer to that would be yes.
To the exemption, unless she was married to a person who is claiming the exemption himself.
But the critical issue is she claiming something that would prevent a forced sale? I mean, that's...
She's not claiming...
Well, isn't that...
She's neither claiming nor benefiting from anything that would impede the trustee or that would impede a forced sale.
And that's really all that the bankruptcy trustee should be caring about and again, it's as you say, it may be a useless asset either way, but if they're giving up their intent and actually not claiming an exemption from forced sale, then they are not receiving the benefits.
I agree with that.
Okay. I mean, that's what Judge Hyman said. It's not...
Well, he goes further and points out that a person who states an intent to surrender or not, perhaps states an intent to reaffirm instead, a concept relating really to what's to be done with a secured creditor, not someone who's barred by the exemption. He would say also that that's not receiving the benefit either, regardless of whether a statement of intent to surrender or a statement of intent to reaffirm was filed with the court.
Because the only issue would be whether there is a bar by the trustee to force sale.
Yes.
Okay.
And thank you very much. I believe you've used your time, but I'll give you a minute if you have anything pressing that you must
just very briefly, Judge. I agree with Mr. Scott to the extent that the real question to be determined is what does the phrase receive the benefits mean? I assert again, following this court's prior cases under the homestead in particular, excuse me, that it means you've gotten your homestead protection. This is a debtor, a woman who had creditors. Her home was protected the day before she filed. The bankruptcy is irrelevant. Homestead is self-effectuating. I would quote, say, benefit, according to Black's Law Dictionary, it's a common term. And it's cited in my brief at page 14. I don't need to read it out to the court again. But essentially, it's a right and a privilege that...
But you would want homeowners throughout this state to actually leave their homes and you think that is consistent with what the legislature intended as long as they're living in those homes as opposed to abandoning and leaving more abandoned homes in the neighborhood, that is what the legislature thought they were doing.
I think they intended this for people who don't own homes. It had nothing to do with abandoning.
Boy, it sure would have been an easier way for them to say it.
Why did they put the homestead in there if that was the intent?
I'm sorry?
Why did they put the term homestead in if it was just for renters?
Well, in their own language, they said it's for people who don't own homes or own a homestead. And again, the concept that Mr. Scott used, or again, where you've got a husband and wife, and again, the husband, let's say, works, incurs all the debts, but the property's in the name of the wife. He's receiving the benefit, even though he doesn't technically own it.
But even if the intent of that section was for people who don't have a homestead, if you have given it up, then you're essentially a person without a homestead, aren't you?
But they haven't given it up, and I guess that's the point, because as Mr. Scott said, if the situation that typically
But
happens...
they have, if you had the right to take that property, then they have essentially given it up.
No. Because what happens here, I know it's, again, getting more into the bankruptcy again, but what happens is they initially, or they don't claim it, let's say, there's no equity. What happens all the time, they say, there's no equity in the property, so we're working it out with our lender, we're trying to get it, we want to stay in the property, but we also want our $4,000. Since there's no equity at that time, from an administrative point, the trustee would abandon it. When I abandon it...
And that's what you did in this case. You own the property as trustee that we're talking about here, right?
Once she eventually...
I understand,
yes.
Yeah, but you owned it.
Correct.
And then you decided that you didn't want it.
because there was no equity at that time, and then it reverts back to the debtor nunc-pro-tunc to the day of filing.
But if you had taken it, then she would have, so that seems to me that you're reading out, when you say receive the benefits, you're reading out of the statute, receives the benefit of a homestead exemption under Section 4, Article 10, which is the provision that prevents forced sale.
Right, which I'm saying she had the day she filed until such time as she abandons under all the law this court has ever ruled.
Well, she's certainly not receiving much benefit from it while you own the property.
But again, she did for the 4 or 5 months post-bankruptcy that she continued to live there that I was unable to touch it. It wasn't until she changed her mind when she decided down the road that it no longer was a benefit to her.
Well, with that, I believe that we have explored this issue and we understand your arguments here. Thank you both for your arguments. The court will now stand in recess. Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.